Wednesday, December 13th, 2023, and I am Brad Connor, filling in for the chair of the Emergency Response Safety and Ethics Committee, Chair Dunn, who's not able to join us today. I am declaring that we do have a quorum present for our meeting today. The purpose of this meeting is to act on important business related to the practice of natural medicine in the state of Colorado. The board will make its decisions on agenda items today based upon written materials provided for its consideration in advance of this meeting. The public is welcome to listen. The public should not address the board unless requested by the board. As a friendly reminder to board members, please make note that some of the material contained in the agenda packet may be deemed confidential. In addition, the board should not discuss legal advice previously received or seek legal guidance in an open session. Such matters will be moved into executive session for discussion. Members of the public will be asked to leave during the executive session. After an executive session, the board will vote on agenda items discussed in the executive session. And with that, I will take roll, starting with me. I am very clearly here. Dr. Hannum?
Present.
Sheriff Lucero? I don't see Sheriff Lucero. Moving on, Dr. Joshua Goodwin says you'll be 10 minutes late, but obviously
Present.
You're here. Thank you. Dr. Tina Gonzalez.
Present.
Commissioner Wendy Buxton Andrade.
Present.
Stacy Lopes.
Present.
Did I say your last name correctly?
You did. Thank you.
And with that, it looks like Ricardo Baca is absent. The sheriff isn't able to join us, and Will Dunn is absent. Is that in line with what you all are seeing?
That's correct.
All right, I will pass to Director Breton.
Well, hello, I'd like to introduce myself, Lori Breton, Program Director, and I want to make sure that I introduce our staff here, which is Amanda Weirs, who's Centralized Services Manager, who has been helping us. We have Monica Sutherland, who is our Policy Analyst, who works on that team. Sam Barami will be joining us shortly. And I know that we have Ian Seafair from the Governor's Office and Allison Robinette from DOR. And we have our AG. Ashley, would you like to introduce yourself?
Hi, everyone. Ashley Moeller from the AG's office, and I'll back clean up and also say that I see Lundy on the call as well.
Yes.
All
That's
right.
it. Back to you, Chair.
Thanks. Okay, and so just as a reminder, either if you can rename yourself and put your pronouns in, or when we do introductions, give us your pronouns. The next thing that we will do is we will go over the meeting minutes from the previous meeting, which was held on November 8th, 2023. And as we're scrolling through the minutes, the meeting minutes, at some point I'll ask for a motion to approve those minutes and to delegate authority to Lori Bratton to sign the minutes on behalf of the subcommittee.
I will move to approve. This is Commissioner Buxton Andrade.
Thank you.
And I'll second Dr. Goodwin. Sorry, Dr. Ham.
Dr. Goodwin gets in for the second. Any discussion, any corrections needed to the minutes as we've seen them? All those in favor of the motion to approve the minutes and delegate a signature authority to Director Bratton, please say aye. Aye.
Aye. Aye.
Those opposed? Those abstaining? The motion passes. That'll take us to the first agenda item, which is introduction of the non-voting participants. Once again, I'll ask you to introduce yourself, tell us where you're from, and state your pronouns. If they're not in your title, or even if you just want to state them, I'll start with Sarah Gale.
Hello, present, Sarah Gale, she, her.
And just tell us where you're coming from, Sarah, sorry.
Oh yeah, Boulder, Colorado. Would you like me to state any affiliations?
Yeah, your affiliation, please.
Okay, great. Contractor for MAPS Public Benefit Corporation, contractor for Integrative Psychiatry Institute, co-founder and board member, Memorial Center for Visionary Healing Arts. Thank you.
Thank you. Dr. Garris?
I'm Will Garris, internal medicine physician, also affiliated with MPBC with the research trials.
And you have your preferred pronouns in your title. Thank you very much. You can also state them if you want, but you have them in the title, so thank you for that. Brandon Burns.
Hello, everyone. Brandon Burns, his, him. Quickly, just asking for an update. We at our company, Peaks Recovery Centers, recently implemented a new CEO, moving to a board position. So my correct title at this time would be co-founder moving forward, not CEO.
Staff, if you can reflect that change, thank you. Erica Messenger.
Hi, all. My name is Erica Messenger. I'm a registered nurse. My pronouns are she, her. I'm a rural health registered nurse located in Southwest Colorado. I specialize in complex and chronic care management and have experience in the fields of community health, public health, clinical nursing, and perioperative care. I'm also a spiritual care counselor or chaplain in hospice care. Thank you for the invitation to participate.
Thank you for being here. Madeline McElwain. Is Madeline here?
I don't see Madeline.
All right, we'll go to the next name, Sam Burdon. Burdon. That's a Freudian slip. Anyway, Sam Burdon. Sam not here also. Emily Holcomb. All right, I'm going to keep moving along. Rochelle Gailey. Apparently no one wanted to come to this meeting today. Not no one. You all are not no one. I apologize. A lot of us didn't want to come to this meeting today. Allison Robinette.
Good afternoon, Board. Alison Robinette. I use the pronouns she, her, and as Director Bratton said at the beginning of the meeting, I serve as the Director of Policy and Regulatory Affairs at the Department of Revenue's Natural Medicine Division. Glad to be here with you.
Thank you for being here. Ian Sieb.
Good afternoon, everybody. My name is Ian Sieb. I'm the Governor's Special Advisor on Cannabis as well as natural plant medicines, helping to lead interagency communication as we look forward to going into rulemaking, both along with DORA as well as DOR and all the other agency communications that are taking place simultaneously. Thank you.
Thanks, Ian. Jonathan Treem.
Hi all, I'm John Treem, pronouns are he, him. I'm a palliative care physician at the University of Colorado, where I lead or direct the ambulatory palliative care clinic here. I'm also the founder of something called the Psyched Public Policy Partnership, which is a group of healthcare professionals whose aim is to help regulators and legislatures enact just public policy in psychedelic.
Thank you. Kristen Spear.
Hi everyone, Kristen Spear. My pronouns are she, her. I'm based out of Broomfield, Colorado. And I am co-founder and board director of Psychedelic Pharmacists Association, as well as a decade-long hospice and palliative clinical pharmacist practitioner. Thanks for having me.
Thank you. Mickey Vogt.
Hello, I am Mickey Vogt. I am a therapist with Cecil Counseling and part of the PPPP group, and I'm here today to help present the screening form that we created.
Thank you for being here, Mickey. All right, I believe that's all of the introductions for non-voting participants. Okay, we're at least on the list. Okay, good. So we'll go to agenda item number 2, which is discussion on video recording recommendations. There is a document that was submitted in the packet for the board members, and at this point, I'll turn it over to you, Sarah, to present that document to us, please.
Thank you. I think you just passed it. All right. Hello, everyone. I am here to present some opinions regarding use and regulation of plant medicine participant session videos in the state of Colorado. I'll be referring to this document, which I co-developed with my colleagues, Dr. Vanderveer and Dr. Scott Shannon, who are not here today. Dr. Scott Shannon is the founder of Wholeness Center and has served as a principal investigator for the MAPS MDMA-assisted therapy clinical trials. Dr. Vanderveer has served as site physician for phase 2 MDMA-assisted therapy clinical trials and also is co-founder of Integrative Psychiatry Centers and Integrative Psychiatry Institute in Boulder, Colorado. And I have served as an investigator and lead educator for MAPS Public Benefit Corporation and have also worked for Integrative Psychiatry Institute as a ketamine therapy facilitator. And so this document was created to provide some insights into how to best use recordings of session videos based upon our backgrounds and experience. Would you like me to go through all of these items or just leave them up here for people to read?
I got zoomed. I don't think you need to read through it, but if you want to highlight important elements as we read through it ourselves, I would assume that the board has read it in preparation for the meeting, so I don't think you needed to read to us. But like I said, part you want to highlight, go ahead and do that.
Sounds good. So we just, in developing this came out of a brief conversation that happened at the last subcommittee meeting, just highlighting that these videos are potentially vulnerable to abuses from participants and practitioners and need to be handled with utmost care and with safeguards in place. And obviously participants should be allowed to view their videos, but we recommend that participants should not be given unlimited rights to use videos. And that these practitioners have a right to privacy and confidentiality regarding their presence in the videos as well. We had our understanding is that it's never been a policy of DORA that video psychotherapy is owned by the client. And in clinical trials and psychedelic assisted therapy practices, it's possible for participants in their more vulnerable post-session state to make uninformed and impulsive decisions regarding how and where to share videos. So some suggestions on approach to following some established practices for video recordings is that DORA would require these video recordings sessions to, all sessions to be recorded, which is standard practice in psychedelic assisted therapy now, and that those videos, in order to, for participants to obtain consent, there would be some paperwork involved for obtaining consent with all parties, and including any parties that are in the recordings, including provider, client, any designated support system, or any other staff that is in those recording sessions, and that these videos should be stored in a locked, air-gapped, encrypted local hard drive for a period of 6 months. And this was just a period of time that was given based upon current practice and for the purpose of having these videos available if there is a need in the future. And yeah, I think one thing that I'll add that we didn't add to this is just a little bit of information on the MAPS PBC clinical trials. So currently in those clinical trials, the pathway for participants to gain access, so MAPS PBC technically owns those videos. The participant puts in a request for access, and then there's a period of time where the participant has access via a link, and there is a signed agreement that they can't record and that they are to keep to view the video themselves. And they are able to request access in the future should they want that beyond those that stated time period.
Thanks. We'll open it up for discussion. I have a couple of quick questions. Well, maybe not quick questions. I have a couple of questions that come to mind, and Sarah, I'd love to ask them to you. So according to the document that, as you presented it, the video recording of a session is not part of the medical record by the way you're defining it, or the record. Let's not call it medical record because we don't, but like it's not owned by the client, so it can't be part of the client record. It must be kept separate or part of the participant record, right?
Correct.
So, that's, and also you make the statement that practitioners have a right to privacy and confidentiality. Do they? Where is that stipulated?
That's a great question.
I
don't have the answer to that right now.
That's fine. And my understanding is that actually practitioners don't have a right to confidentiality or privacy in the terms of when they're administering services. So for instance, like I can't control what my clients say once they leave my office. So I'm a licensed psychologist, right? So once my clients leave my office, I can't control what they say. And if I find that they're defaming me, I don't have I guess if they're making things up and lying about me, I would have a right to defend myself. But if they're saying things that happened in the session, I don't really have a right to have any recourse if I disagree with how they're portraying what I did, do I? And anyone who knows can answer. Sorry, Sarah, go ahead.
Yeah, absolutely. Anyone else feel free to jump in as well. Yeah, I think I would believe that you're correct in terms of what is verbally shared from clients about their sessions.
Right, and so I would push back on this idea that practitioners have a right to privacy or confidentiality, because I don't know where it would be defined and if it would be that much of a blanket statement. I think there are obviously limits, right? Like, but I don't think it's that much of a blanket statement. And so I think that, and then I think about, there's a mention somewhere in the document about, thanks for providing the document, by the way. I think it's really helpful for us to start the conversation and I think what we want to do. But the idea is to say, like, so if I went and got my knee scanned at an MRI, I do in fact own the copy of that as a client or as a patient. If I go to that imaging center and I ask for a copy, they will give me a disc that has all of the imaging that was done on my knee. And so, I mean, I know that because I've had my knee scanned a number of times and I've always gotten a copy of it. So this idea of limiting a participant's access to the video, I mean, I think that the strongest argument you make in here is that in the post session that they may be in an uninformed state and may make impulsive decisions, means that we wouldn't share the video with them right after an administration session or potentially even in an integrated session. But it's hard for me to see from this document why a participant wouldn't have unfettered access to videos from the session. And so I just wonder if there's more to speak to on why you would limit participant access to their own videos.
Yeah, I think for me, most of what I've showed in here, I think is, coming from the organizations that I've been a part of. And I would say that, so I wasn't involved in the decision-making around videos at, say, MAPS Public Benefit Corporation. So perhaps what I would recommend is that the subcommittee receive, some further advice from the individuals who made the decisions, and I can help to, put you in contact with those individuals. Just want to speak to that I haven't been the one who, as a director at a clinic, has made those decisions, either at IPI or MAPS Public Benefit Corporation. Will Vanderveer, who helped write this document, has made his protocols at Integrative Psychiatry Center. He wasn't able to be here today, but that is a question that I think would be better suited for him.
Thanks for that. And then one thing to keep in mind, I think, as far as I understand it, MAPS is operated as part of in the sense of research. So maybe there's a bit of a difference when we have people who are participating in research studies. I believe that the researchers then do own the videos. But if we're talking about things in a practical experience, I would question a little bit. But I'll stop talking now and I'll go to Erica first. Erica?
Thank you, Chair. So I used to do some HIPAA, although this doesn't fall under HIPAA, I used to do HIPAA training for hospitals. And Sarah, if you could correct me if I'm wrong in this, but going back to the right to privacy and confidentiality, instead of right, if we said expectation, is that kind of what the intention was with this document? So it's more of an expectation of privacy and confidentiality, meaning the practitioners really are expected to maintain privacy and confidentiality, not necessarily that they have a right to it, meaning from the participants or from the clients. Is that kind of what this meant?
Yeah, absolutely. And I would love to get, some information. I wonder if there are other video session recordings that happen in other modalities, right? So Dr. Connor mentioned photos. I actually don't have this information, but would love to see if there are, other examples out there that would be analogous to the situation, whether that's in psychotherapy, mental health, or medical services that are actual video recordings, that would be a recommendation.
So I can speak to that quite quickly in terms of psychotherapy. So we run a training clinic for clinicians who are in grad school who are learning to be therapists, and we video record all of their sessions. And the clients do have access to those videos recordings should they request them, but they do need to make a request. And then the clients can also request that we destroy their video if they don't want us to maintain it. And they do have to sign video consent. So they have to sign video consent before we start video recording. That consent indicates that they have the right to have access to the video, and they have the right to request that the video be destroyed, and that essentially they are the owner or holder of the rights of the video.
And are they allowed to do whatever they want with those videos? So can they go post them on YouTube? Can they just have full?
If we give them a copy, they can do whatever they want with it. Yeah. Eric, your hand is still up. Did you want me to come back to you, or was that just a remnant?
Yes, one more comment just about the psychotherapy notes, which Dr. Connor, even under HIPAA, psychotherapy notes are not the right. So
Right.
someone could request medical records, but they can't request psychotherapy notes.
Correct.
So I feel like this is just something the board is going to have to develop, is this privacy and confidentiality that doesn't fall under HIPAA until it is HIPAA qualified, like insurance covers it.
Right.
But we're, just going to have to come up with that.
Yeah, and just a
policies
comment.
around it.
As a follow-up to that comment on that, we've talked off and on here about HIPAA and this idea that whether HIPAA applies or doesn't apply. Here we're referring by statute to individuals who participate in natural medicine as participants, and given that HIPAA is a federal law, I don't know that it applies in specific cases. So it may be the case that this advisory board is advising the regulatory agencies to develop a state-level privacy protection for this specific entity, for the natural medicine, and that may be something we have to tackle as we go through this process, or we see if we can get things that already exist to fit to what we're trying to do here. But I do agree with Erica that if you consider the video recording part of the clinician's notes, which I think would be a stretch to be able to do that, then you could protect it. But that's the only thing that we're allowed to protect are our own notes, and not the client progress notes, but just the notes I take about what happened in that session. That's the only thing I'm permitted to protect as a licensed psychologist. Dr. Hannum.
Yeah, so just to echo what you say, I do a lot of prolonged exposure therapy that requires recording, and I do, the clients do own those recordings and can do with those whatever they want. In fact, we send them home with them, but without a request. My question was about, so originally in Dr. Connor's original ethical code, we had made the recommendation that participants be required to either have video recording or a second facilitator in the room. And the issue that we ran into was really coming from members of our Indigenous Religious Use Subcommittee, who expressed that they felt like requiring video recording might be a violation of their spirituality in a way that would really not be feasible for certain populations. So I don't know if anyone here could speak to that, or just kind of bringing that issue back in, because I think that's something we need to consider. That's part of the reason we made that change.
Erica, did you want to speak to that issue? Go ahead.
Sorry, again.
No, it's okay. Don't apologize.
There are actually tribes in New Mexico, I believe it is, where if you go there, you cannot take photos of them. They believe it steals their spirit. So I would think videos would absolutely fall under that.
And Josh, I'll come to you in just one second, Dr. Goodwin, but I just want to make sure no one else has comment on Dr. Hannum's request for comment around how spiritual indigenous populations might receive a mandate for recording. Dr. Goodwin.
Yeah, I don't have anything to say about that. Well, I guess, I have three comments just in general as we talk about developing this policy. The first thing is, we were talking about looking at other modalities that they give you some type of, video or whatever. The issue is it's a Schedule I drug, right? And it's not legal in a lot of places in the United States. So it could do more damage to somebody if it was released than, say, a photo of your knee or, some traditional methodology. So I think that is something we need to, be concerned about, right? Like, if we want to take care of the people that are under our care, maybe we don't want it released so that someone could just put it on YouTube and get us fired from our job, or, unlicensed from whatever we have, depending on where we're at in the state. The other option, or the other comment, is that I think the discussion is simpler when you're talking about one-on-one, but it becomes more difficult when there's like 4 participants in there, and then there's 4 people on the video who may not, again, want to be put on YouTube, and so we're going to have to delineate that. And then the last thing is, we were talking about someone signs a consent form to get it released. We're going to have to put some caveat in there for like disciplinary proceedings, saying that, if someone files a complaint, against the provider, they can share the video without the consent of the participants in that. So those are the 3 things I thought of as we were going through that. Thank you.
Dr. Goodwin, you have said something that has sparked our resident lawyer to raise their hand, and so we'll go to Ms. Muller.
Thanks, I appreciate that. I agree completely with Dr. Goodwin's last point, which is if there's a complaint filed against a facilitator or as part of a regulatory scheme, you're going to have to contemplate disclosure of those records and that information to the regulator, right? So that's piece number 1. I think that's well contemplated. I do want to kind of dip back to the Act and talk about the director's powers and duties in Section 12, 170, 105, which talks about confidentiality requirements for licensees, right? This is not confidentiality for clients, but for the licensees. And so these records that are related to a participant, information or records related to a participant, constitute medical data as described in 2472-204-381. And the information or records may only be disclosed to those persons directly involved with an active investigation or proceeding. So I was frantically looking back for that language. I as this discussion was going on, I do think that there is a conversation that you guys need to have around recommendations for the scope of disclosure to a client when requesting these records. But I do want you to keep at the forefront of that discussion the fact that the Act itself considers these records considers records about a participant to be medical data, number one. Number two, may or may not be subject to HIPAA. It doesn't explicitly call it out in your Act, but we probably need to address that. And so we do need to be cautious and thoughtful about how we capture this information.
So, Ms. Muller, can I ask you a question? I should wait for you to answer if I can ask you. I'm going to ask you a question. And that is to say, if the state statute indicates that participant records are in fact medical records, then by default, does that make them HIPAA protected? Isn't that what HIPAA protects?
Yeah. I mean, I can go through and I can parse it. I mean, I get that this is a Schedule I drug, but I think the intent of the Act is to capture it as a medical record. As certainly, it explicitly says it constitutes medical data.
Right, so when I wrote the ethical code, I reviewed HIPAA, and I reviewed the statute, which is why I stated in the ethical code that the information should be subjected to HIPAA, because even though it's a Schedule I drug, and even though HIPAA is a federal law, if the statute stipulates that the records from these participants are medical records, then my assumption was that they would be then governed by HIPAA.
Yeah, I mean, there's no doubt that, and this is tricky, and this is something that I'll have to perhaps look into a little bit more closely, but the Act is sourcing it back to CORA, the Open Records Law for Colorado, and basically defining the records, right, maintained by licensees as falling within that category of documents defined in CORA, which are medical, mental health, sociological, and scholastic achievement data and electronic health records on individual persons. So CORA is a statute that talks about disclosure of records maintained by a state agency, right, upon request by any requester. And so certainly the plain language of the Act says that this state program can't disclose records that are maintained, that it gathers, that are maintained. But does it go further than that? I mean, I think that's an analysis that we need to think about.
Yeah, and I would say, and Eric, I'll come to you in just 1 second. I would say if you think about what we're considering in terms of psychedelic assisted psychotherapy, that once you start talking about mental health diagnoses, then that information must be protected without a doubt, right? And so for all of those reasons, either we need to write something that looks just like HIPAA as a state law, or we need to make sure that HIPAA would be in play here. Erica?
Yes, exactly. I was going to suggest that we create something that the board creates something very similar to HIPAA, but the covered entities, there's things called covered entities under HIPAA. So a covered entity would be like a healthcare provider, which would be a doctor, a clinic, a psychologist, a dentist, a chiropractor, nursing home, pharmacies. But only if they transmit any information in an electronic form in connection with a transaction for which HHS has adopted as standard. Okay, so that's number one. Number two is a health plan that includes health insurance companies, HMOs, company health plans, or government programs that pay for healthcare. And then the third is the healthcare clearinghouses. So those are the three covered entity categories. So if it's not under that, it doesn't fall under HIPAA. That doesn't mean that the board can adopt almost an identical idea for HIPAA, but it just wouldn't be called HIPAA.
Thanks, Erica. Allison.
Thank you, Chair. I just wanted to piggyback. I know Ms. Muller was pointing to Title 12, but wanted to let the board know also that there is very similar confidentiality language in Title 44 in the Department of Revenue's Natural Medicine Code that requires the Department of Revenue to maintain the confidentiality of sort of the long list of data that Ms. Muller just listed as well. So wanted to add that as a layer of texture to this conversation, because recognizing that not all facilitators may be associated with a healing center, but a healing center must have a facilitator at least contracting with them. And so with regard to the healing center side of things, we would be certainly looking to that confidentiality provision for any data we have, and similarly working with the AGs who represent the Department of Revenue to evaluate, how far does that reach? So I wanted to flag that.
Thanks, Allison. Erica, your hand is still up. I didn't know if that was a remnant or... Yeah. Rochelle?
Hello, I just wanted to share some information from the Behavioral Health Administration, and our rules would permit an individual to have basically unfettered access to their record as long as there's no concerns that the access would put the individual in danger. And it does say that those procedures have to be visible to the clients when they enter the building, as far as how they might access their records and how they might appeal for a grievance if they were denied access for some reason. So just from our point of view of licensing addiction and mental health treatment settings, we do allow them access to their records, generally speaking, and they can grieve that if they have concerns regarding stipulations on that access.
And can I ask you a couple follow-up questions, Rochelle?
Sure.
Do you know, would that cover video recordings? Would you consider video recordings part of the record?
Yes.
Yeah. That's good, thanks. And then, there was a second question in there. Do you know of any professions that BHA works with that mandate video recording?
We don't mandate video recordings, but some mental health centers do have video recordings in a room as they monitor individuals. And that is not maintained past a certain point in time, which they would have to maintain the record, which is usually 7 years.
Yeah. And so, I think the other thing we want to take into consideration here is that based on the rules that DOR is likely to enact, that healing centers are going to have video recordings happening all over the place, maybe, like in terms of the entries, the egresses, where the products are being stored. So we should maybe be differentiating types of video recordings. And here I think we're speaking specifically to video recordings around of the administration session. Just want to make sure we're all on the same page. Sarah, go ahead.
Yeah, I had a clarifying question for Rochelle. So is it the case in those clinics that the videos are then under the ownership of the clinics themselves, and that the individuals are allowed access, and then that those are deleted after a certain period of time?
I think it's similar to what Dr. Connor was saying. There are videos for entrance into the building that are on loops that may not be maintained in someone's personal record, but those that are happening within a unit, a bedroom, can be stored as that person's record.
Dr. Goodwin.
Yeah, so, I'm a little concerned about the complexity of this, right? And I've been saying this from the beginning. Like, we lean a lot on kind of current medical practices and, for psychologists and therapists and all of these things. But we have to remember that the policy that we're building this for might be the standalone entrepreneur who does not have advanced medical training, and they don't have a full team and legal experts to unpack all of this. And so I think we need to build something that is reasonable, that one person could understand and also put into practice. And so, you know, as we're kind of layering these things on here, I think we do need to pump the brakes a little bit and kind of distill it down to what's really important and to make it so that it's usable for kind of the people that are going to do it. Because I think that the folks who have advanced medical training, they're already going to have these rules in place. So,
yep, I think those are well-made points. I think one of the reasons in the ethical code we stipulate that you can either request video recording or a second person present is to address some of that those complexities. You know, there are certain costs associated with being able to make a video recording and then store a video recording of a session. Not that you all need to see around my office, but there's a reason there's a computer behind me and a computer in front of me. That computer behind me is an air-gapped encrypted computer that has no access to the internet, right? So in order to be able to store documents the way that they're suggested in this document, you would likely need a second system in order to do that. And I think that's gold standard. I'm not complaining about that, but it brings us back to the thing that we're always talking about in these subcommittee meetings, which is the balance of the need to keep people safe versus the need to not cause these programs to be so expensive that people get priced out of them. I don't think an air-gapped computer necessarily puts someone out of the market, but it is something to consider. If we're going to require video recording, that means we're requiring video recording equipment, we're requiring storage, we're requiring air-gapped storage that's encrypted and often needs to be a second machine. So it adds the complexities there, along with the complexities that Dr. Hannum brought up around how that might impact spiritual religious use, ceremonial use, and those things. So I think we're all feeling the weight of the complexity of this issue. And Sarah, I hope you don't feel like we're attacking you or attacking the document too much, but these are things we've been thinking about for a while, and I think this provides a slightly different perspective. And so I just want to make sure you're not feeling like we're being mean to you or anything like that. So.
Not at all. Different perspectives are very important.
Okay, great. So where we're at now on this is that I think we can, the board can take this document in, mull it over, and then make some recommendations around video recordings. I don't want to close off the discussion too quickly, so I'll leave a second to see if there are any other comments about this document before we move on to the next item on our agenda. So any remaining comments around this document on video recordings and how we would use video recorded sessions before we move to the next agenda item? Again, I really appreciate the submission of the document, and I think after we've had some time to review it all, we'll probably revisit this at the next board meeting for the subcommittee, assuming that that's what the chair would like us to do, and we'll continue to have discussion with the recommendations that we make for the rulemaking process. Thanks, Sarah.
Thank you. Happy to continue part of the conversation as it unfolds. I do have a hard stop today at 2, but I'll be here for the next 20 minutes. Thank you.
Great, thank you. So that would take us to the next agenda item, which is agenda item number 3, which is a discussion of the authorized healing center recommendations. And here, that might be slightly misworded. This is the work that I've been doing to draft some language around authorized locations other than healing centers and what they may look like, how they may go about getting licensed. And I don't want this is the draft. This is the first thing I wrote. So I don't expect this to be perfect. I expect it to get commented on, torn up, or maybe even thrown away. But just as a setting, a couple of months ago now, I don't remember, I don't have any sense of time anymore. But at some point I agreed that I would start working on definitions of what it would mean to be an authorized location other than a healing center. And as I started working on it, the issue got more and more complex. As an example of complexity, one of the first questions I asked was, could a licensed facilitator facilitate out of their home? Could that become an authorized location other than a healing center? And I think the quick answer to that was no. Then it would need to be considered a healing center. They need to go through the licensure process. The next was, if an entity that wants to serve as an authorized location other than a healing center currently accepts Medicaid or Medicare, would it be possible then to administer a Schedule I substance or have an individual administer to themselves a Schedule I substance on the property? And it seemed like the quick answer to that was no, that people would be unlikely to want to jeopardize their ability to receive federal funding by allowing for the use of Schedule I substances or any scheduled substances without express permission or something like that. So this document reflects a lot of that information, and what you'll see if you've looked over it is me trying to address a lot of those points. This document is in no way done, nor complete, nor comprehensive, but just my initial thoughts. And with that, I will have I'll leave a couple of seconds here for you all to look it over a little bit more, and then we can have some discussion about it. Erica.
I'm sorry, Chair. I didn't get this document ahead of time, so I'm trying to read it on the screen. But just going back to the point you just brought up, so what hospice clients and end-of-life clients, where would they fall into that may not be able to travel to a healing center?
So what I put is that I think let me see if I can find it. Locations. So I think it's point 4. If you read that one in detail, that's where I tried to address it. So locations are licensed for and I don't know the proper language here because I know that therapists' offices aren't necessarily licensed, but something on the side of the locations that are licensed for the provision of medical or mental health services shall automatically be considered authorized locations. So in that vein, a hospice center would automatically be considered an authorized location other than a healing center, but that they would have the right to that a hospice center would have the right to refuse to be a facilitation or an administration area should they want to do that. So what I tried to do was make it so that established locations that have already been licensed and are providing medical or mental health care to individuals don't need to apply for a separate license to be an authorized location other than the healing center, but also make it clear that they do not have any obligation to provide those services, especially if it would jeopardize their ability to receive federal funding.
So all of my clients are located in the home. We don't actually have a hospice center. Would that fall under that as well? If they were
so there is some language, if you look at point 6, and if I can get the document scrolled so we can look at point 6. So point 6 here, private residents shall not be approved as authorized locations other than healing centers for the administration of natural medicine on a continual basis, however, may apply for authorization on a participant by participant basis. So what I don't want to do is I don't want someone to declare that their house is an authorized location other than a healing center always. But I think so in this case, you would apply, the way I would envision this, and this is just right here, it doesn't exist anywhere else, but the way I was envisioning when I wrote it is you would apply for permission to go to somebody's house for that person specifically to receive natural medicines in their home. This would require you to get the natural medicine from a cultivator or healing center, to take it with you, to make sure that they took what dose you brought, and then to maintain custody of the natural medicine that was not administered, and then to take it back to the healing center or destroy it. It was my sort of solution to the problem of how do we authorize houses was to make it on a participant by participant basis, that they would have approval only while they're receiving the services, and and so that's the way I tried to manage it, if that makes sense.
Yeah, it does make sense. Thank you so much for doing that. And just as a point of clarification, are we calling people who participate in therapy participants or clients?
Right now, the language in statute dictates that we call them participants. So I try as hard as I can to be using the word participant.
Yes, thank you for that clarification.
Dr. Hannum.
Thank you, Dr. Connor. I think this might be an elegant solution to some of the things we've been kind of struggling with on this issue. I'm guessing in terms of applying for private residence to be an authorized location temporarily, DOR would be taking those applications. And I guess my question might actually be for them, because part of my concern with that, the one concern I have is that sometimes hospice cases move very quickly, and we would want this to be a kind of a rapid process. So I don't know if someone from DOR could speak to that.
Yeah, and while we're waiting for someone from DOR to determine whether they want to wade in these waters, point 1 here stipulates that the regulatory agency shall be responsible for authorizing these locations. And so I did put it to the regulatory agency, whether that's DOR or DORA. I didn't decide, but I just left it to regulatory. Alice?
Yeah, thank you, Chair, and appreciate the sort of forethought in trying to create a space where the agency can be nimble enough to respond and to, have a line of sight to where administration sessions are occurring. I don't have any specific thoughts, but I tend to agree that if there's an application process, that means there's a fee required. It also means, and I see here under some of your points, like a physical inspection, it's unclear how quickly some of those things could happen, and especially if a facilitator is looking to move quickly, it could create some challenges. There may be other ways, though, that we can put some safeguards in place that may be more about, for example, when the facilitator takes possession of the natural medicine that they will be taking to the administration session, putting in requirements about, what kind of information needs to be included in that sort of transportation manifest that the facilitator that is responsible for I think there are some things we can do with this framework to refine it and streamline it in a way that if this is the way the board wants to move forward, and if our team sees it as operable, that we could make it work so that there's at least that line of sight. The other piece of this that I know you all are certainly aware of and have at the forefront of your mind, but thinking about that distinction between privacy and government oversight, it gets very uncomfortable when, for example, like a detailed safety plan of someone's home is being submitted to a government agency, and some folks just may not be comfortable with that. So I think these are all things we can work through, and interested in being able to provide you some written feedback and additional information as well as ideas.
Yeah, and thanks for that, Allison. And Erica, if you do get a chance to look at this in some more detail and you have some specific recommendations, I think this board would love to hear them at our next meeting. So if you wanted to, you could submit a document to Lori Bratton, a week or two in advance of our meeting, and it would make it into the packet. And again, you can destroy this document. I'm not going to get offended if you tell me that all the things I wrote are stupid. We've covered this before, so I would really appreciate it, Erica, if you felt if you felt like you had the time to do that, to give me especially feedback on this idea of going into people's homes. I'd love some more information. Allison, your hand is still up. I'm not sure if it's a remnant or if you have more things to say.
I wanted to make, sorry, go ahead,
Erica. Sorry, I'm so sorry, Allison. I don't have a copy of this document. How can I get that?
Lori, can you make sure that Erica gets a copy of this document?
Yes, it should have been sent over to you just a few minutes ago.
Perfect. Thank you so much, Lori. Apologize, Allison, for interrupting. Thank you.
Thanks, Lori. Thanks, Amber. Yep. Go ahead, Allison.
I just wanted to, before I forget, I think generally speaking, Department of Revenue does not want to license private residences. And so to the extent that we can provide safeguards and to have a line of sight to administration happening outside of healing centers, but we are not, I don't think it would be appropriate for the department to license private residences as healing centers.
Right, and so I wonder if there's a way to change that framework a little bit to say that a facilitator could get a license, a part of their license could indicate that they are permitted to administer in private residences as long as they're following certain recommendations. I see head nod. I'll go with that's a good idea, and I'll make some adjustments to it. Ian.
Thank you, Dr. Connor. I have a question as well as a couple of things. For clarity, can you just repeat? I thought that I heard you say under number 6 that these would be limited to participant homes only, but I didn't see that in number 6.
Sorry, I interrupted you. Go ahead.
Just in regards to the doctor from the question from the doctor who said that she would host it in her own home. So I'm looking for some clarity in terms of what you're thinking about in regard to private spaces.
Yeah, so the language that I could add this, but I did not, but is the idea that it would be in participant residence, not in facilitator residence. So anyone who's got a license to be a facilitator would need to be operating in a healing center or in an office space or some professional space, but not their own home. If they wanted to go the route of having it be their own home, they would need to get that location licensed or authorized, and it would not be by default or automatically. And this was to try to avoid this idea of skirting the healing center process altogether, or the healing center entity altogether, and just saying, I'm going to operate out of my home, and then not having to get that home licensed or authorized in some way.
Okay, thank you for that point of clarification. Understanding what Allison just said, one of the things that I'm sure that has been considered is recognizing that those who are engaged in this regularly, setting being of great importance, may have a better opportunity to create an ideal space for somebody absent a licensed facilitated space or licensed healing center, and that a client home may not always be most ideal.
But can I interrupt you for 1 second, Ian, just to make sure I'm understanding what you just said, is to say that, I think in general we would prefer we weren't going into people's homes. I think in particular we're interested in being able to go into people's homes for specifically what Erica was talking about was the idea of hospice and end of life issues where we don't think a person could move. So we wanted to make sure we provided an ability to do that, but I think it should be somewhat limited, and it's not yet currently limited in the document as I've drafted it. But is that what you were suggesting, that we shouldn't have an open policy to be going into people's homes?
No, the opposite, just recognizing that, somebody although in some cases the set and setting may be great and a participant may be most comfortable in their own home, it may be in some cases that a facilitator understands, better for a participant what an ideal space may look like as they go through creating a space. And in some cases, that might be in a facilitator's home as opposed to a participant's home, recognizing what Allison said, that DOR may not wish, it's not desirable to license the facilitator's home. Just want to add, I think that there's some give and take in both, for both, and why both are important to be considered.
Yeah, and I know probably people are getting sick of me drawing parallels between this work and the work that I do as a licensed psychologist, but I'm going to do it again anyway, which is to say I would never bring a client into my home and do psychotherapy with my client in my home. And if I were going to do that, I would create a very separate and distinct space, and then I would expect that distinction would be obvious to the participant, and it would be clear. Like, so this is an addition to the house or a part of the house that's blocked off. But then there are rules around the way that a licensed psychologist might operate, and so I think we'd still want to pay attention to that. And I also want to make sure that we're clear that while I've said earlier in this meeting that I don't think that a provider should have a right to privacy or confidentiality, they certainly have a right to safety, and so they shouldn't be compelled to go into an environment where they don't feel safe. And so I want to balance that perspective as well, to make sure that the facilitators always feel safe in administering natural medicines and would never be compelled to provide those services if they didn't feel safe.
Understood. And related to that, two more things. Related to that with what you were talking about in regards to the investigation, or not an investigation, pardon me, getting my compliance words mixed up. In an inspection, and Allison speaking about just the inability, the likely inability to do so efficiently to the satisfaction of a participant and a facilitator, is that there may be some consideration for allowing a facilitator to go into a participant space to take a look out of it, and some type of attestation between both the participant and the facilitator that allows some level of comfort for the agency that the facilitator has signed off that they feel comfortable in the space to allow the facilitation to take place in the participant's space, absent a full inspection from regulators.
So if you look at 6A2, which is on the screen in front of you right now, the physical inspection is actually by the facilitator or an authorized representative. I didn't expect the regulatory agency to go to each individual's home, but I do think it would be through that attestation process. So the way I envisioned this is that if an individual facilitator wanted to go into an individual's home, they would file for permission to do that in some way, and they would attest that they've already done a physical inspection of the space and they deem the space safe, and they would provide a copy of a safety plan so that the regulators are simply just looking over paperwork, but not actually going out into the field.
Understood, and thank you for that. Last thing that I'll point out is just in letter B under there, 6A or 6B, is that there are both public and private campgrounds, and I think that your intent is to talk about more related to public campgrounds, but if somebody has private established campgrounds, I think that there's going to be, I envision that some will look to create a space that is more outdoors and more like a campground space, but on private land.
Yeah, I was specifically thinking about like natural parks, natural forests, or national park, national forests, local, state parks, things like that. So I'll change it to read public campgrounds or public recreational spaces. Does that seem like that would work?
Yes, thank you.
Yep. Mickey.
Hi, yeah, this was more to kind of address what Erica was talking about in rural settings as well as in a hospice setting. And then this issue with, would we then have to be putting in for an approval for every single residence each time? And so I'm wondering if maybe we can address all of those things by creating a specialty license beyond what a healing center that would allow this person to be able to identify this as a safe place, like a person's home. And part of their getting that license is they are being trained on how to identify that as a safe space, so that they're not needing to, for each place they're going into, request permission, which I think, especially in a hospice setting is going to, like, the time and resource personnel that would require for that whole thing to happen every time you're going into somebody's home, I think is extensive and excessive. And so if we can, in the training piece of obtaining licensure if you would like to get a license, if you're a hospice provider or you're in a rural setting, that would also then allow you as the provider to identify that this is a safe place per pre-identified standards, then you can do that. And then of course, if something happens, that's on you and your license, just like we face now with anything that falls under the scope of our license.
Right, yeah.
I don't think that would be given to everyone, but something that, you could pursue if it's relevant to you.
That sounds great. Mickey, I'm going to summarize, and then I'm going to go to Dr. Goodwin, and then I'll go to Dr. Treem. So it sounds like what I'm going to do is rewrite point 6 so that it's not authorizing locations or participant by participant, but instead providing maybe an extra license or a specialty license for individuals who want to provide in-home care that requires a certain amount of additional training to be able to evaluate the locations, including whether they're safe or not. I'd still probably have it be related to a specific participant rather than a specific location. And then they'd probably have to have a safety plan developed and then have it on file or something along those lines. So I just want to, like I said, I'll come to the good doctors in a second, but just as a way of amending 6, if there's comment or question about the way I've just described it. So unless I hear an objection, I'll revise 6 to be housed with the facilitator rather than with the location and incorporate the things I just discussed, and we'll discuss that in more detail in the January meeting of this subcommittee. Dr. Goodwin.
Yeah, so as we're talking about healing centers, I have kind of 4 quick points. The first, and I think I attribute this to Sam, if I remember correctly, but it seems like the powers that be are interested in maybe a phased approach to this, where because it's the new industry, we start out playing it safe in a healing center, and then as things are going well, there are more insurance providers and people who are feeling more comfortable with it, then we can expand out to some residential places. And so this doesn't have to roll out on day one, right? We can pack this out in a phased approach, and so I want everyone to remember that. 2, I'm concerned that the healing centers are going to be a stovepipe to this whole thing, right? One, if you can only do 1 or up to 4 people at a time, then you're going to have to rent a space, right? Or you're going to have the overhead and the capital to run a space, which is going to create issues for people in getting into the market. But if only certain people own the healing centers and facilitators have to rent space, now you just stovepiping care. And I'm concerned about that. Okay, that's a piece that we need to discuss. The next part is insurance. We had a briefing from a company that was interested in providing it was like a malpractice or like a liability insurance, and they were very conservative, right? Like they didn't want to even touch residential areas yet. They were kind of open to exploring it, but they weren't all in with both feet. And the people who were trying to set this up were having trouble even finding folks who would back this thing. And so it's going to be difficult to get insurance in the beginning anyway. And so I'm not sure if someone has a commercial space as a healing center, that they'll be able to get even general liability insurance for this. I don't know if that's going to be a problem. And so again, it goes back to the stovepipe thing, and it's something that we haven't even discussed yet. And I think the last thing, and I've been saying this from the beginning, and I keep losing this argument, is that if we're in a residential area, I would rather the facilitator do it in their own home, unless they're like, there's an ambulatory issue, or there's a hospice thing and they can't move. And I've said it because, you know that there's no weapons around, that there's no other drugs or, some type of toxic substance around. Those are things that we've talked about. And for some reason, I keep losing on that. But if it was between doing it in your own home and then going to someone else's, I would rather the facilitator have control of the area.
So let me ask you this question. Would you rather do it in your own home?
Yeah, if I was going to do it, yeah. Yeah, if I had like a really nice basement or something, and I was going to bring him in, yeah. Instead of going to someone else's home and let him go into the bathroom, pull out a shotgun, and blast me with it. But I was a federal agent for 2 decades, so.
But I'll say to you, I'll say to you as someone who provides clinical mental health services, the last thing in the world I want are my clients inside my home. I don't have any urge to have, and so I think that's more of a difference of opinion. I don't think you necessarily lose that battle. For me, what I don't want is I don't want someone to use an authorized location other than a healing center exception to always be facilitating in their home. If they're going to do that, my recommendation would be that they get their home licensed as a healing center, and maybe that's where there's some nuance. It's it's not that I'm against it. I just don't want people trying to even keeping things uniform by allowing for facilitation in the home without some sort of regulatory license or authorization to do so. So does that make sense?
It does, yeah, it does. It just, it just goes back to that idea of the stovepipe.
But can I interrupt you real quick? Can you explain this? I don't get the stovepipe thing, and that's maybe my own ignorance. What does it mean?
It's like where everything just gets hung up in this one place because it doesn't have the bandwidth.
Oh, like a choke point.
Yeah, a choke point's good. Yeah, right. So if you're required to go to a healing center, and let's say that only 2 or 3 people have the money to run a commercial space full time, and then they have to hire these facilitators to come in, or facilitators, need this space, but they can't afford one on their own, so they have to rent space and it's just not available. Well, now you're causing just kind of stovepipe to care because you have to attend this thing. And again, I'm not even sure that you're going to be able to get the protections you need as a business owner to even hold one of these commercial spaces right now. And so if we say day one, you have to have this to even do it, then it's dead before it even starts.
Well, if I present, so if you think about, I hear what you're saying, and I think about if you look back at, if we can scroll up a little bit, and Dr. Treem, I promise I'm coming to you very soon. You're waiting very patiently, I appreciate that. But if you look at point 4 specifically, so it says locations that are licensed for the vision of, and again, I don't think license is the right word here, but the idea is to say that the spaces that are already being used for medical or mental health services shall be automatically considered authorized locations other than healing centers. So for instance, I have a private practice office where I see clients. That is a space that's been used as an office for clients. That office should be automatically considered an authorized location other than a healing center where I can facilitate a natural in the way that I've written it. So try to get around this issue of what you're thinking about in terms of the large commercial spaces that are likely to become healing centers where they may be cultivating on premises and producing on premises and then facilitating on premises. The ketamine model as it stands right now in most states in the United States for low dose ketamine, not high dose ketamine, is that the participant or the client or the patient goes to a compounding pharmacy, they get their ketamine, and then they usually go to their therapist's office, and then they use the ketamine in the therapist's office while the therapist sits and facilitates with them. At least that's one model that's used in a lot of places. And so I can see that sort of model being used here, except for that the facilitator would need to maintain custody of the natural medicine rather than the participant or client or patient. So hopefully that addresses your stovepipe issue slightly, and that there would be automatically a number of locations where facilitation could also co-occur.
Well, but the last thing I want to push back on that is that we know now that if you tried to bring a Schedule I drug into any of these places to get federal funding, that they would lose that, right? We talked about that.
I don't know that we know that now. We've always known that, but yeah, we know. Like I can't.
Yeah. Well, I recently did it, and we know too that like banks, right? Once banks find out that you're dealing with Schedule I drugs, they'll drop your accounts. Would the insurance companies do the same thing for your practice now once they find out that you're doing these things? We don't know. Like we haven't had that discussion, and so we don't know that those protections would still stay in place once you added this element into the practice. And so, these are all. I don't have an answer. I'm just throwing. Before we lock these in, we got to know that there's some unknowns.
I think they're all really good points. I think in this instance, the closest analog is ketamine-assisted psychotherapy or cannabis-assisted psychotherapy, and I agree with you. There are almost immediate limitations, right? So you're gonna have difficulty getting a bank account for sure, especially if you put something in the title of your business that indicates that you're dealing with natural medicines. You would likely quickly lose the ability to get a bank account, right? And I think that what was the other point that you made? Oh yeah, so like the same thing, like whether you can bring it on premises or not. Like so, for instance, while there are a bunch of cannabis researchers at CSU, none of us can actually do cannabis research on campus because we're not permitted to bring cannabis on campus. So automatically we have to go off campus if we want to do that research. And I think trying to avoid as many of those nuanced interactions as we can would be important to not create a more complicated or convoluted system. So I really do appreciate the points you're making, Dr. Goodwin, and thanks. Dr. Treem, as promised, you're up.
Thank you. Really interesting and nuanced discussion. The only thing I wanted to add to it was the possibility of, I hate to sort of ask the board to consider, making the licensure itself more complicated, but there's something like a mobile administration, sort of like secondary licensure might be appropriate here. And the reason I say that, I'm a palliative care doctor, obviously, I also do hospice. You all are very likely to be aware that hospice is really an insurance designation at its core. and that hospices are essentially paid per diem by insurance companies to provide end-of-life services, and that most of that is actually based on CMS rules, so Medicare and Medicaid services. It'd be very hard for me to imagine that a hospice even with a trained facilitator in psychedelic practice who goes into a home under the guise of hospice itself to administer natural medicines, that wouldn't essentially be a government-based insurance company paying directly for the provision of natural medicine services, which I think would put the hospice at major risk. So, it's a way of saying I think that the provision of natural medicines in a home environment is very worthy, especially to the homebound population, the end-of-life care population, but it would probably have to exist essentially as a secondary subset of licensing, potentially for like a mobile unit. So like a regulatory access model, like that is a wellness center, it's just a mobile wellness center.
Do you think would you envision then having some sort of requirement of what the mobile center looks like? So, or are you thinking like bus, van, or are you thinking of someone driving up in their car? Like, did you have any suggestions there what the mobile process may look like?
I haven't even thought about it. So I would be remiss off the top of my head. I would imagine that it would require essentially the same kind of oversight as essentially medical regulatory, like mobile medical administration practices, right? So there are medical vans, there are essentially medical services that go into the community, for example, into the homeless population that are essentially, regulated, do have oversight and licensure to actually do that. There would have to be something similar as opposed to just like a dude in a car.
Right, yeah. Imagine a mobile facilitator's license and they pull up in some sort of white van and ask you to step in the back of the van, right? Yeah, so sure. Ian, thanks for those points, Dr. Treem. Ian.
Thank you, Doctor, and thank you, Dr. Treem, for mentioning that. I just want to have no input or opinion, but I just want to call out for what Dr. Treem just mentioned, that DOR, the Marijuana Enforcement Division, does have a license type right now that is a cannabis license type that is a mobile hospitality license. I recognize it's a little bit different, but simply want to offer that as it relates to regulating cannabis right now, they do have licensed facilities that are brick and mortar that do not travel, but there is an allowance for these mobile hospitality specifically for the purpose of consumption outside of a licensed hospitality facility. And so recognizing that there's some clear differences here, there is some parity, and there's perhaps, if you're looking, Dr. Treem, for some more help in terms of kind of fleshing out your concept and your idea, I would encourage or invite you to look at mobile hospitality rules with the Marijuana Enforcement Division.
Some sort of psychedelic party bus, Ian, is that what you're suggesting?
I'm not at all suggesting that this would be a group facilitation, but same type of thing does exist in the retail cannabis space. If a group mobile facilitation was to be desired.
Thanks for the suggestion, appreciate it. Erica.
I just have this picture in my mind. But this is to Dr. Treem's point. So Dr. Treem, I know that medical aid in dying, or MAID, is legal in Colorado, which assists dying in those who are at end of life. Is that hospice covered? Do you happen to know? Those medications, are the hospice covered?
They do, and it's not. Can
I just interrupt for one? Because can we just get, for those of us who don't operate in the medical field, can we just get a more clear explanation of what we're talking about in that sense? Are you talking about providing medications to assist someone in passing and dying? Okay.
Yes, that's correct. That got passed a few years ago. It is not widely used, but it is legal in Colorado. Yep. So the medications are provided to the dying to assist them in dying, and the whole point is to end suffering. It's not to create dying; it's to end suffering. They're already going there. So, but Dr. Treem is saying it's not covered under hospice, and I wonder if we could look at some of those rules, how that works with hospice. Hospice care and CMS, to be able to see if we can fall, psychedelic assisted therapy can fall under something similar.
I can give a little insight. I'm sorry, this is funny. I'm here, with a different hat. I also do a fair amount of advocacy work around aid and dying in Colorado and nationally. For what it's worth, aid and dying is an out-of-pocket expense for all people who participate. Insurances won't cover it. Hospices cannot provide the medication themselves, and most hospice directors either consider it a direct conflict of interest or worry about kind of federal prohibitions around essentially dispensing aid and dying within the context of hospice. And hospices, that said, can facilitate end-of-life care services when somebody chooses aid in dying of their own volition. Right? So if somebody goes to a process with their providers and is able to obtain an aid in dying medicine, hospices can absolutely administer services around the willful ingestion of that medicine, but not necessarily provide the medicine itself. So there is a corollary here, I think, that you're bringing up, which is appropriate. Which is that the services and mobile services for the facilitation of psychedelic therapies likely can be covered by insurance carriers, essentially, because that is a mental health or physical health benefit. But the delivery of the medicine itself, I think, is the thing that that's always the hang up for aid in dying. I assume would be the same.
Dr. Sheen, would you like to work on that hospice document with me? The hospice recommendations for the board. Thank you.
Thanks, everybody. I think this has been a really useful discussion. I did want to come back to a couple of the points that Dr. Goodwin made, and see, Sam, do you want to comment, or Lori, or I don't know, even Allison, about where we're at in terms of the staged approach that Dr. Goodwin mentioned, or are we? Are we go into rulemaking in the next couple of months? Are we trying to do all of it, or trying to do parts of it, or are there thoughts around this idea about authorized locations other than healing centers? Go ahead, Ashley. You're on mute. You disappeared from my screen.
I have some ideas. Thank you for that. And I'll just kick it out. The one thing that I want to just remind everyone of is the fact that rulemaking is not a single moment in time that will last forever. Rulemaking is something that happens with some frequency and regularity. And so there may be multiple phases of rulemaking. And so I don't want everyone to feel the pressure and constraint that once we shift into rulemaking, that's the end all be all and the only time you're ever going to experience recommendations and a rulemaking process, because rulemaking is a thing that can happen over time and with modification. So
I think, if I could interrupt you for a second, we were all hopeful that rulemaking would mean that we could all relax a little bit, but apparently you're saying it doesn't mean that.
and you might be able to, and let me be very frank and clear with you. This board and this subcommittee has done an extraordinary amount of work in the time that it's been together, and you guys have created a ton of information and recommendations that are evolving into what feels like the first and perhaps most significant wave of recommendation, but that doesn't mean that that's the end of your waves of recommendation and the end of rulemaking. So please do not get overly confident that once you make this recommendation that you're done.
Yes.
You're not, but it also, please don't feel the pressure of coming up with everything right this very second, right? Like there's you're building a program from the ground up. You will hear me say this at your full board meeting. There is a lot going on, and you have created quite a bit of work product to kind of go into your first round of rules, but that's not going to be the last say. And so you have time to continue to evolve and develop the smaller nuances.
Thanks for that. I do want to say that I did prepare this document with the idea that it would probably be a couple of iterations before it became finalized. And now that we're meeting on the schedule we're meeting on, that would probably put this document into the next round of rulemaking, not likely to be in this round, but things can change. Lori?
Yeah, I just wanted to say thank you to Ashley. That was really great explanation of the rulemaking process. We will start with what we're mandated date-wise to have completed first. So that is where we'll begin in rulemaking here in the spring. And when we have completed that, we will, as she said, continue on to other areas, different sections, those that overlap, and it will be a lengthy process over the next year or years as we adapt and find that we need to make some changes. So I'm sorry, Dr. Connor, it will be a while.
All right, I appreciate it. I like doing the work. Allison.
Ashley and Lori both. I mean, on every single point they made, and I just wanted to share from DOR's perspective, we do not see this as a one and done rulemaking, and especially how we can be helpful is in particular like a concept like this, where there probably are multiple operable paths that we could help you explore as you think about where you want your recommendation to go and what you think the best policy would be. And so answering specific questions and things like that, those are things we can do while identifying, okay, what is our authority? Where are there gaps in authority? Where are there potential legal risks, which I would defer to the AG's office, Ms. Mueller and her team, as well as the AGs that represent the Department of Revenue. But that's all work that we can help you work through. And I would say, I know there were a lot of other concepts about how to accomplish this, whether it's through different license types, there could be permit opportunities, and those are things that we also want to be able to advise you if we think there needs to be more statutory direction. If it's going to be a separate license type, what are the license privileges? If it's going to be a permit, who can obtain that permit? So those are all things that, as you know, this is the first iteration, and future iterations, we are fully prepared to support that work and help you, help all of us figure out what's going to be the most operable path.
Thanks, Evan. I'm going to ask you a question, Allison, as a follow-up to a previous point, so it's going to seem like a non sequitur, and then I'll go to Dr. Hannum. But if we switch this point to the in-home administration to being a special license type, then does that move to DORA, or do you think that stays with DOR?
I think that's part of the conversation. You may have seen, it's a lot of us typing back and forth. We're all talking, there are overlapping authorities between the departments. And so I think that's part of what I was mentioning is figuring out what the most operable way to accomplish what you all want to accomplish could mean looking at, is it a Department of Revenue license or a National Medicine Division license, or is it more appropriately attached to the facilitator license that DORA is administering? So those are exactly the types of questions that I think we can work through.
Great, thank you. Dr. Hannum.
Hi, sorry. I have to sign off, and I apologize for that. I'm really sorry to miss Dr. Treem's presentation and the work. I just want to say that I did read through the white paper and the screening instrument, and I'm incredibly grateful to that group for putting that together for us. At our last meeting, we had talked about me creating a flow chart based on screening. So I do have an ask that if something comes of that discussion, that Lori Bratton can communicate that to me if I have a do out about that. But other than that, is it possible to do my attestation?
Yes, and then you received some work product from Sam, some things I put together around the screening stuff.
Yeah. So I more information would be helpful. Yeah.
I'll make sure a report gets back to you, Dr. Hannum. So, Dr. Hannum, do you attest and affirm that all conflicts of interest have been disclosed and the confidentiality of all board matters has been maintained since the previous board meeting?
I do, and thank you, everyone. This was a really great meeting today. Thank you very much.
See you next time. Okay, so thanks for all those. Those are all points for us to consider and taking into consideration. And then I think that, like I said, I didn't expect that this one. I think this is going to take us some time to finalize it. And so, just speaking back to that point, I didn't expect that this document would be going into the first round of rulemaking. And so I don't want to put a rush on this document because I think there are a lot of really important points that we have to still continue to consider. So I'm going to take back the suggestions and the discussion points that we've gone over regarding this document. I'll update this document, and distribute it to this subcommittee in advance of our January meeting to continue discussion on it, and potentially distribute it to other subcommittees to have some comment from those other subcommittees on it as well. We have two remaining items on the agenda. One is the presentation on the screening tools, and then another is just to go back over our consolidated recommendations and talk about next steps. But before we do that, I'm actually going to have us take a short break right now, since we're about, what I see is about halfway through our agenda. So we'll take a break now. It's 2:20. We'll come back at 2:30 p.m. Mountain Standard Time. The board will take a short break. Please ensure that all cameras are turned off and that everyone is muted during the break. The meeting will resume at 2:30 p.m. everybody. It's 2:30 Mountain Standard Time, my clock, so I'm going to call us back into session. And as we're coming back in, we'll prepare to hear from, Dr. Treem on screening for psychedelic assisted psychotherapy, or in this case, psilocybin assisted therapy. Before Dr. Treem, I turn it over to you. Let's give a brief update on, there's work on this same topic on other subcommittees as well, primarily on the qualifications training subcommittee, where we've had some discussion, and that was what Dr. Hannum was alluding to as she was leaving, in that I had taken on a task of identifying potential screening tools that we could be using and assessment tools, and I had sent those to Sam and Lori, and Dr. Hannum had been working through those and developing a flow chart for how they would be used or when they would be used. So I just wanted to give a little background on work that's taken place up to this point. And I will say, Dr. Treem, that I'm very much looking forward to the presentation. I've reviewed the documents, and I think that the tool that you provide is one that would, is very interesting and likely to be something similar to, if not what we adopt in the use, and along the same lines as the way that we've been thinking about it on that other subcommittee. And so, not to steal your thunder, I think the work you've done is really helpful and really great for us. So with that, I will turn it over to Dr. Treem to present on screening tools. Materials for this are the actual screening instrument and then this white paper that you all should have in the packet that was distributed in advance of this meeting. Dr. Treem.
Thank you, Chair. Real honor. I'll say a couple things up front. One, I'm really here with several other people who I invite to chime in and sort of do a little bit of a co-presentation. Dr. Garris, you heard from earlier, Erica Messenger and Mickey Vogt, all of whom were absolutely instrumental in developing the resources that you guys were given. So just to introduce, this was this document was formulated by a group called the Psychedelic Public Policy Partnership, which is a group of healthcare individuals in Colorado with no specific financial affiliation, but really dedicated to helping the state and regulatory bodies enact, safe and just public policy around psychedelics. So, the screening tool itself, we really feel like is a cornerstone for essentially several, critical measures of public safety around psychedelic use. One is to essentially help guide clientele to appropriate facilitators, as you guys have worked very diligently to define, especially around the sphering structure. And so, what clientele may be most appropriately seen by any facilitator versus who may need a dual license facilitator, essentially for safe access to psychedelic policy. So we created a screening tool with that in mind, with the ability to use this tool specifically to help delineate who might be at higher risk for adverse outcomes in the administration of psychedelics. And the secondary part of this, obviously, is when it comes to kind of the rule mandate around data, and what data might be collected and how that might be used to improve the administration of psychedelic therapies. We recognize that the screening tool itself is probably actually an important initial repository for data, especially when it comes to measuring outcomes or effects or effectiveness of psychedelic therapies in Colorado in the future. So a couple important things before we jump in. I know you all have had an opportunity to read through this. I'm sorry we didn't give you a whole lot of time. I will say the rationale is this is not meant to be a comprehensive forum to assess essentially the spiritual or cultural context that a person may be using psychedelics. It's not meant to assess essentially intention or what a person hopes to gain from that. That's we thought would be secondary conversations with trained facilitators. This is really meant to be a mental health and physical health screening tool to identify things that are that may portend higher risk in the administration of psychedelic therapies. And the second part of this is that most of the stuff that we sort of in at least the mental health profession use to compile tools like this are based on, data based, meaning or empirically based, meaning when there is evidence to argue for or against different types of preconditions that may comport sort of advanced risk in the administration of any therapy, we try to use essentially data to support those kinds of conclusions or those kinds of tools or risks or screenings. I will say in the administration of psychedelic therapies, there are very few sort of empiric sources to really help guide who's at highest risk. So the white paper that you were given was really meant to be a justification or rationale for the screening form that was developed, meaning where there was evidence or credible medical evidence in the literature to support a recommendation, we tried to cite that and call that out in the white paper. When it was sort of more of a matter of public opinion or expert sort of perspective on things that could be potential pharmacokinetic interactions or sort of pre-existing medical condition interactions with psychedelic therapies, we try to say that as well. All right, enough introduction. Dr. Garris, Erica, Nikki, anything to add to any of that?
No.
No, you said it perfectly.
Then the screening form itself is divided into 5 parts that we thought would really kind of be the best buckets for how to assess risk. General healthcare considerations, medical health considerations, mental health considerations, pharmacology, medications, and supplements, and then special considerations. The form sort of details it. I will say that the goal of this form is to help facilitators delineate responses to any individual question that would fall into one of 4 categories. One would be, based on the response, proceed with standard safety counseling. So, this does not feel like it, elevates any risk. 2, proceed with a facilitator developed safety plan. So, okay, there's something on your form that may require, a little bit more safety or a little bit more conversation around safe practice, but that it can be facilitator developed. 3 would be responses where the recommendation was to proceed with a medically developed safety plan. So in consultation either with a higher sphere or secondary sphere facilitator or with medical or behavioral health consultation. And then the 4th would be do not proceed, so what we consider to be contraindications to psychedelic therapies. Again, the sort of empiric basis for this, especially whenever we talk about things like contraindications, we try to make sure that we have sort of citations that would back some of that up. So, for the form itself, the start of is, in the general healthcare questionnaires, the things that we really want to highlight are things like pregnancy, and asking people about pregnancy status. You'll see in the white paper, data on safety in pregnancy is very minimal from a medical standpoint. In general, whenever we approach the issue of pregnancy when it comes to any therapeutic, unless there is a known safety profile, we really try to limit a pregnant person's exposure in utero. That said, whether or not that would be an absolute contraindication or whether that would be consultation, I think we would leave to the expertise of the board itself, but that's an important question. Breastfeeding similarly, the degree to which psilocybin or psilocin actually infiltrates breast milk is not well established in the medical literature, right? But is enough of an issue that it should be addressed essentially in the screening form, and there should be a safety or risk counseling sort of conversation for anybody who's breastfeeding. General medical conditions. So the way that we sort of approach this, and I hope this is evident in the screening form, is that a complete medical questionnaire about all aspects of a personal medical history is essentially overly laborious, would be a major barrier to access for people who are seeking psychedelics or psychedelic services. So really we try to focus a little bit more on what we call functional status. So is there something that is a significant impairment in a person's life, right, that may make the administration of a psychedelic in the regulated access model more complicated, right? And then essentially cue additional conversations through the screening form. So rather than it be a comprehensive questionnaire about all interactions, say, okay, really, how did this person fill out this questionnaire, and how might that help alert them to sort of potential issues that they might need to investigate further? All right. So questions like, okay.
Dr. Treem, do you mind if I add to that real quick?
Please do, yeah.
So this form was designed as for SPEAR 1 facilitators, not for SPEAR 2 or SPEAR 3. And just as Dr. Treem was saying, some of the answers to these questions may trigger a SPEAR 2 or SPEAR 3 facilitator or facilitator screening or referral to one of those facilitators. So that's kind of the idea behind this. This is why he's saying it's not comprehensive. It's meant for SPEAR 1 facilitators.
Right, so questions like, do you need assistance with toileting, ambulating, transfer, medical devices? Can you walk 2 blocks or up a flight of stairs without difficulty or getting winded? Right, those aren't necessarily pointing to specific medical conditions, but to sort of give facilitators some sensibility about potential difficulty in the context of a psychedelic administration. Other things to sort of call this committee's attention to are several kind of important things, right? So I won't sort of be overly long-winded, but there's a lot of debate in sort of the medical and mental health community around preconditions and applicability of psychedelics. So when it comes to things like the mental health questionnaire, we did ask about some specific preconditions in behavioral or mental health. And the rationale for asking those specific things as opposed to general questionnaires is meant to be empirically based. So, for example, you'll see in mental health section B, B1, any thoughts of causing harm or wanting to cause harm to yourself or others, or are you currently, currently or actively having thoughts of wanting to end your life? There's some signal in the medical literature that suggests that for people who are actively suicidal in the context of psychedelic therapeutic services, there is a brief period after an administration in which they may actually have heightened senses of suicidality. And most of the medical literature suggests that anybody who is actively suicidal is actually screened out or excluded from participation in the trials that sort of guide our therapeutic practice. So it feels like an important question. The other thing to consider, especially in the context of a form like this, though, is that if you ask a question, and this is true for any therapeutic environment, you have to be able to respond to the answer, right? So, if we're asking people about suicidality, which feels actually pretty critically important for public safety in this context, when they say yes, right? Then essentially you would assume that there is some imperative to connect that person with, essentially crisis services for mental health. And so you can imagine, like we said, when we were developing this form, we recognized that this form connects to a number of different initiatives within sort of the context of psychedelic therapeutic administration that would need to be sort of worked out. Same thing for what it's worth when it comes to the pharmacokinetics of psilocybin specifically. There are some medications that likely are inhibitors or inducers of the enzymatic pathways through which psilocybin travels, right? So things that may portend a different experience if the person's taking them. One, most famously, is alcohol. So alcohol is an inducer for an enzyme called aldehyde dehydrogenase, which is one of the enzymes responsible for the metabolism of psilocybin and psilocin. Right? So people who are heavy drinkers are likely to actually have blunted effects, meaning they have usually overactive aldehyde dehydrogenase pathways such that the conversion of psilocin, the active component of the psychedelic in mushrooms, to its essentially inactive metabolites is likely to go much more quickly. So these are, anyway, I won't go through every question here. It's just meant to say that the form was developed essentially with all of these things in mind. I will absolutely turn the rest over to Erica and Dr. Gowers, for essentially additional insights, and then we're happy to sort of answer questions.
Dr. Garris, did you have anything to add?
Just quickly, the alcohol question also in my mind is also to make sure that they don't go into withdrawal, or there's a risk of alcohol withdrawal during the session or after the session. I don't have any other. That was great. Thank you, Dr. Treem.
Yes, thank you, Dr. Treem. Okay, so this is a client screening form. It's designed to identify potential sources of concern with or contraindications to psychedelic assisted therapy. So a therapeutic outcome discussion form, it's just a name we kind of came up with, but things like, what is your intention for this? Ways to measure outcomes to see if they're getting the therapeutic needs and getting a good result from their therapy, which is the whole point of them being there. It's not meant to replace a client intake form, so that beginning area that asks the name and all that stuff, there would be a separate client intake form, but it's just a little additional information to help the facilitator. Also, this form is not created for the general public yet. It should be whittled down to about an 8th grade level. So should this be approved, that's something we would work on to bring the language down to a readable level for the general public. Also consideration of administering standardized depression, anxiety, and trauma screening tools, such as the PHQ-9, the GAD-7, the PCL-5. Those are considerations. Again, those are measurable, quantifiable tools in order to measure therapeutic outcomes. So current documents that were utilized to consider this form and create this form were the Psychedelic Public Policy Partnership Screening White Paper. That was the foundation for this form. Recommendations from Dr. Kristen Spear on the pharmacology section. We did look at the Oregon screening tool and pull out things from there that we thought were relevant. We consulted the Handbook of Medical Hallucinogens and ketamine clinic screening tools for psychosocial questions only in the various research publications. So as we went through this and came up with our questions, there were several questions we asked ourselves as we went along the way. Number one, is this relevant to client preparation screening or the day of screening? If not, we shouldn't ask it. It's none of our business. Is this for Sphere 1 facilitators? And then number 3 would be, is if they say yes or no to the question, does this qualify them for something? Is there evidence to support it? Those questions should be highlighted as disqualifiers or postponers. And you'll see some of these questions in here are highlighted in bold. We consider those disqualifiers or postponers for psychedelic assisted therapy. So things like lithium in the past 2 weeks, pregnancy, certain mental health conditions. Those are all things that are highlighted in bold to kind of cue the facilitator that these are disqualifiers or postponers until that can be absolved. And then yes answers, if they don't disqualify the client, how will we respond to a positive indicator of potential concern, which should be a part of the training as well for a facilitator. And then does this question need a clearance from a mental health or a medical healthcare provider for participation or a referral to a mental health or medical healthcare provider or other services? Couple things to consider as well, music and eye shades, which we didn't include as part of this tool. Those things in the spirit of trauma-informed care, I brought this up before. I know that this music and eye shades were used throughout research. However, screening for client comfort and preference with the environment, and I think we spoke to negative stimuli in here or triggers, but these are things to consider. For example, German composers may trigger some sort of re-traumatization of someone who identifies as Jewish. Eye shades could trigger a trauma response for people who are victims of captivity, sexual abuse, certain other types of abuse. So those are other things that we could consider for this form. But right now, the 4 or 5 categories, I believe it is, special considerations, those are the things that we came up with as the key things, items of concern that should be screened for. So these are recommendations, and the board is charged with deciding whether or not these are appropriate.
Thanks, everybody. I appreciate the presentation. I do have a couple of follow-up questions. Some are general and broad, and some are a little more specific, and maybe I'll work backwards from specific to broad. There's a note, if we go, could you scroll to D pharmacology, please, Amanda? If you look in the medications check you're currently taking, and lithium in the past 2 weeks is in bold, which you had now indicated would be a disqualifier. It says in the past 2 weeks, and then there's 2 stars. I couldn't find where those 2 stars show up again. can you all speak to what is the interaction between psilocybin and lithium and why that would be a concern?
That's a question for Dr. Spear, or Dr. Dream, sorry.
Yeah, no, I can speak to that a little bit. So there's one study, that demonstrated that the co-administration of lithium with psychedelics significantly increased the seizure risk in individuals who are seizure prone. I will say that it's relatively low in terms of the total N, and it's not been validated in larger scale studies, but it's never been investigated either. Right. Oregon does use lithium as a disqualifier for psychedelic services for that exact reason, based on that exact study. That said, the reason it's starred on this form is because the amount of time that you have to be off lithium in order to minimize the heightened risk of seizures in seizure-prone individuals is unknown.
Right. So that's my next question. Yeah.
Essentially recommended 30 days. The truth is that, lithium as, in terms of its metabolite structure is likely not present, in any meaningful concentration in the, serum or tissue of the body after 2 weeks. So we're not totally clear why 30 days was used, but that said, I don't think there's any evidence to kind of help guide.
Right, but so I guess the question that comes, and I appreciate all the information, and I've seen some of that stuff, and I agree with you. I don't think 30 days is necessary. I'm not a medical doctor. I don't know anything about a lot of those processes, or I'm not supposed to speak to those processes, obviously. But I think with this other point in this is the interactions or the co-consideration. So for instance, let's say you have an individual who's diagnosed with bipolar disorder and they're taking lithium, and we ask them to stop taking their lithium. Isn't that likely to potentially increase the probability of having a manic episode, or potentially also increase the probability that they're going to be thinking about ending their own life or potentially harming somebody else?
Yeah, I mean, I think the answer is absolutely, right? There's an elevated risk anytime you're going to ask somebody to discontinue a medication that's, essential essentially to their mental health or their physical health, right, for the purpose of facilitation or participation in a psychedelic therapy. I would say that that's part of the reason we say something like lithium, probably, that's probably like a do not pass go, as opposed to go ahead and discontinue. Or if you're going to discontinue, you probably need to be doing it under essentially active, medical recommendation and observation with a trained licensed therapist or trained licensed medical provider, right? So it's just a way of saying, yeah, I agree, but this is not meant to be a form that says, go ahead and discontinue these things when they have some degree of interaction. It's meant to say these are all medications that if they are taking them, essentially it would trigger that sort of like, you should probably have a medical or psychiatric consultation before you participate. That's one. I would say the other parts, that are worth mentioning here, because we talked about pregnancy, we talk a little bit about things like lithium, we talk about suicidality and psychosis in this form. There's compelling evidence in the literature that for essentially all individuals, there's transient, elevation of blood pressure and heart rate in the context of a psychedelic administration. It's probably essentially an independent mechanism. And that for people who are potentially have significant risk with, aberrant elevations in blood pressure, people with heart failure, people with pulmonary hypertension, people with, predisposed cardiac arrhythmias with pacemakers, things like that. We actually talked about whether or not it would be reasonable to screen people day of administration, essentially for blood pressure, and whether an elevated blood pressure above a certain systolic or diastolic was essentially a contraindication. This form doesn't cover all of that, but what I will say, and I think this is very important, is that this form does ask for the co-development of a safety plan model, right? So basically, the idea is this: we're going to screen, right? And some people are going to fall into a category that we would consider to be higher medical risk or requiring consultation with a secondary license, and then the co-creation of essentially what a safety plan actually looks like, right? So it's not just like you're seeing someone who's like, I don't know, they told me to come see you about this, right? But
yeah, so if you look, if you look even in the ethical code, there's a section in the ethical code that I drafted that has a series of documents that are required. So first I want to say I appreciate the comprehensiveness in the document, and I'm not trying to detract from that at all. I think it actually solves a problem for Dr. Ham and I as we were working through the all the available psychometrically validated instruments that we might want to use. There isn't a screener like this that exists, and so I appreciate you all doing this work. I do think that there are points where, and this is one of my broader questions, which I'll get to, but there are points that you could probably cut out because they'll be covered in other areas. So for instance, the transportation plan, it will be mandated that all participants must have a transportation plan, and it will be mandated that all participants will have, safety planning and things like that. And so I think that some of this stuff, if you were creating this document in a vacuum without any other documents being recorded, would have been it is really comprehensive and covers a lot of bases, but as it's written now may cover some areas that are being covered by other documents at the same time. So I think it's a great, and like you said, a great level 1, let's say, or sphere 1 screening instrument, whereby certain questions may not disqualify an individual, but would definitely elevate them to a higher level of care, or to needing to see a specialist before to seek approval, or to not get approved to take natural medicines in the way they're being used in the state of Colorado. So I appreciate all that. This document was created for this purpose, or is it being used for other reasons?
It's created exclusively for this purpose for this board.
All right, appreciate it. Is there intellectual property to try and protect with the document?
None. It's free use.
Great. And so if it's, I'm going to invite discussion from the rest of the members here. So if you all have questions, you can start raising your hands. This is an area of expertise for me, and that my minor is in quantitative, and I've developed a number of scales over the course of my career. And so I'm really intrigued by the instrument. And so, I'd love to hear comments from board members, from other non-voting participants around both the presentation and the document as you've been reviewing it. So opening the floor for comments. Dr. Goodwin.
I love the document. It is extremely comprehensive, and I think that pretty much everybody who takes it is going to land on this thing somewhere, right? And that's great. But I don't think that we need to collect a bunch of information if we're not going to see the patient. And what I would love to see, and again, I'm not a medical doctor, so this is just a personal preference and a suggestion, is to rack and stack the questions where if it's a hard no, you get that option. Like if you say yes here, skip to the bottom and sign. You don't have to give me your entire life history, because I'm not going to see you because you're schizophrenic and the voice is telling you to kill me and everyone else, right? So I don't care if you drink 3 times a day. So I think that would be awesome. And then I think past the hard nose, even if this requires a sphere that's higher than me or whatever, or higher trained than I am, then we can stop there as well. Like if you said yes to this, I can't see you, you're going to have to go see someone else. Just so that if it is a screening tool, that's the idea, right? That we know that they're not a right fit for us. Let's move them over instead of taking their entire history every time. And so someone doesn't have to do that multiple times. That would just be my suggestion. But other than that, I do love everything that you covered, and I didn't see anything on there that I didn't like. That was great. So excellent work. Thank you.
Thanks,
That's great. I love that idea of putting them at the top of the category, having those hard no's as the first in the document, and then putting anything that refers them out to the top of those next categories. That's really a great idea. Thank you, Dr. Goodwin.
In a perfect world, one of the things I'm hoping for is that the data collection that's required by the state will be done so electronically, which would leave the probability or possibility for programming with branch options, so that if a person answered a question a certain way, you could branch right to it's time to elevate you to a higher level or a different sphere. I don't know that we'll get there to make them all electronic forms, but it creates that space for branching and for that kind of flow or process. And I'll say that this is the document that will go into the battery of test measures that we've already collected, and then Dr. Henham's working on that flow chart and that priority list and how things would be administered. Dr. Spear.
Thanks, Dr. Connor. I think one of the things that I wanted to point out here too was that the medication table is probably going to be updated, or a revision suggested to be a little bit more robust, to remove some of the duplication of medications in the same classes, maybe more clearly highlight some that are probably a hard no, especially if a patient cannot taper off medication. For example, benzodiazepines, which are known to potentially abort a trip, antipsychotics, which are also known to do the same or even make the experience worse. So I am working on an updated medication table, and I'll submit that to the group here probably by the end of the week. The other thing I wanted to point out ask to the panel is, what is the utility of asking questions for data gathering purposes? So for example, There, especially with drug interactions, everything is theoretical, and we have basically no data or literature to support anything very strongly. So when there could be a drug interaction or adverse outcome reported, would we want to be able to trace it back to certain medications that could or might have created a problem? For example, inhibitors of UGT enzymes, for example.
Yeah, so there is a mandate in the statute about the minimum level of data that needs to be collected, which does include information about adverse events. And there is another subcommittee that I am the chair of, which is products, data, and research, where we're trying to develop what the system of data collection is going to look like so that we could potentially be able to benefit from the data collection to answer questions like that, or to be paying attention to what those interactions might be, to try to add to the literature base, to be able to, hopefully answer some of the vast number of unknowns regarding the use of psilocybin or the safe use of psilocybin. So I don't know, Dr. Spear, if that directly answers your question, but hopefully it did.
It does, thank you. And so I think with some of the ideas I have for submitting a few more of these medications, I'm trying to balance not being overbearing for the participant, but also being useful for some of these medications that we may assess and gather data points on. So thank you, it does help.
And Dr. Spear, I would recommend that you include those medications that you think are necessary, even if that list is maybe too big or too long, because my guess is that things will get pared down on our side, not expanded. And so I would opt on the side of being more inclusive rather than less inclusive at your step, because that's just the way these things seem to work.
That's really easy for a pharmacist to do. So thank you.
Yeah, sure. Dr. Goodwin.
Yeah, Dr. Spear, to add on to that, and just to tie it back to this subcommittee, it's also that if there is an event and emergency responders show up on the scene, the facilitator would be able to tell the emergency responders everything that's in their system so that they can provide better care. And so as you're building this list, if you can think of anything that an emergency responder should know as well, that would be helpful for this.
Thank you, Dr. Goodwin.
Yeah, and what I'd suggest, if it's okay with the team, is based on the feedback, and by here I mean the team of you all who created this document, based on the feedback you're getting from us right now, whether you'd want to go at revising it and then bringing it back to the January meeting. At some point, I would love to be able to take a step at helping out with revising it. I can't meet with you all separately outside of these meetings, so I'd have to wait for you all to update it, then send it to me, and I'd work on it and send it back to you with marked up copy, which is fine. I mean, I've been doing that along the line. I mean, but that would be the way that I would suggest proceeding. Rochelle.
I just want to ask a question about the buprenorphine and the Suboxone, as we might have people who are on medication-assisted treatment for opioid replacement therapy seeking this treatment. Can you help me understand the counterindications for those types of medications?
So here, just to be clear, you're talking about Suboxone and methadone primarily, and buprenorphine, sorry?
Yeah, yeah.
Yeah. Any of the Dr. Spear or Dr. Treem or Dr. Garris? Or
I can add some thoughts. So I think initially when these medications were added, the idea was including opioids and opioid agonists as a potential for central nervous system inhibitors or reducers. Depressants is what I'm trying to think of, which could impact the safety and sedation levels of a participant during experience. However, from a pure drug interaction standpoint, I think they may perhaps be less clinically exclusionary, if you will. They might be more of something to be aware of and to dig in a little bit more on their frequency, their reason for use, whether there is something more of a concern that the facilitator or higher level other sphere facilitators should be paying attention to.
Yeah, I would add to that only that, yes, I agree with Dr. Spear. This is not meant to be an exclusionary criteria list. Right? It is meant to be sort of a list of medications that may impact the experience that a facilitator might want to be aware of in terms of co-administration.
Great. So thanks for all the information. I actually have a follow-up question to that point, and that is to say, if we're going to look at these potential drug interactions, who would be the best person or the best what would be the best license tech to review drug interactions? Is that an MD or a PharmD? Or does it matter? What are your recommendations there?
I would say that I feel comfortable with MD, PharmD. I would say that APPs are likely, sort of APPs is the advanced practice providers, so nurse practitioners, physician assistants. I would say that some qualified nurses, absolutely, but I'm not sure if Dr. Spear, Dr. Karas, Erica, or Nikki have any other opinions about that.
I think perhaps in the screening tool and the white paper, which gives more of a justification for why we're asking these questions, and the decision support will help with that piece. I agree that a PharmD is probably a good option as well, but I also understand that not every there's a lack of providers that might be available to look over this type of medication list. D4 I think is an appropriate question. So when we do have a more robust medication table, the goal is to screen out or to identify those medications that are potentially more risky and need more investigation or perhaps education for the patient. But if it goes beyond that and the patient or the participant would like to receive medication review more closely, I think at that point, somebody experienced in that could be elicited, brought in.
Yeah, so the reason I asked this question specifically is, as Dr. Dream pointed out when he was presenting, in the world of psychotherapy, if I administer a measure that asks someone if they're considering hurting themselves or killing themselves, or hurting somebody else and killing somebody else, I am now charged with responsibility of doing something with that information. Would that be the same in this medication checklist? So if I check a box and then I have a drug interaction, is the person who's facilitating likely to be held legally responsible or civilly responsible because they didn't do something with that checkbox? Dr. Cheem?
I can give my 2 cents. I would say I'm certainly not a legal person, so there may be sort of nuances to this that I don't understand. That said, I think that we'd like to follow up this form with essentially recommendations for how a facilitator might respond when people check things, right? So it's rather than just being like, well, they checked the information, good luck to you. Just being like, if this, if this. It's not going to be comprehensive, but I do think that point, right, which is like you're charging actually the facilitator administering this form with a fair amount of medically sensitive information that you would need a backup system to essentially allow them to connect people to appropriate resources when they answer things in certain ways.
Yeah, I would say I appreciate that, Eric. I'll come to you in just 1 second, I promise. I appreciate that. I think in particular, this medication section is one that I would ask you all to pay special attention to. And the reason I say that, as far as I know, and certainly Sam or Lori can correct me, there's not a PharmD on the board, but there are multiple licensed psychologists. And so for the mental health decision-making trees, I don't know that, and not to say that you all couldn't provide us with that information, but we can probably cover that. But in terms of the medications, like if someone checks the box for haloperidol, I don't know what I would do with that information. And so certainly the decision trees around medications would be really helpful, because if without that, I think it would almost necessitate that it get reviewed by somebody else in order to make sure that we're not creating legal risk for people. And so if I could just make sure that you all are attending to even that one section with the specific flow chart of information, we'd find, well, at least I know, I won't speak for the entire board, but I'll speak for myself and Dr. Hannum and say we would find that very, very helpful if you could provide that to us, Erica.
So for the screening tool, we didn't want to go a bit further until the board decided whether or not they liked it and we were going in the right direction. But the idea is we would create basically a tool to go along with it, basically a client or participant response tool for the facilitator to take the guesswork out of it. So each one of these points would have, if yes, then this, if no, then this. So they would know exactly what to do, and we're happy to work on that if this were approved. The other piece was about the, so we talked about this, and Mickey Vogt can probably speak to this as well, but we had talked about maybe putting this into an electronic form. As soon as you get into paper, you have to deal with how are we going to handle that paper? How are we going to dispose of that paper? This is a lot of very sensitive information on here. And so, one of the recommendations or things that we were talking about is have an iPad or something like that, some sort of protected electronic form of this instead of a paper version.
Yeah. So just as a point that, like I said earlier, so there's another subcommittee which is going to be charged with a lot of that work, and so there's often overlap in the subcommittee work, but it might be really beneficial, and I'll say that differently, it would be really beneficial to have all of you come to the data, or not maybe all of you, however you want to do, have some or all of you come to the product data and research subcommittee and present this as well, because that's where so this board is going to be charged with safety. So here you will think about that flow chart that you're talking about. That would be of most interest to us. In terms of programming into an electronic document, in my mind, the way I'm organizing that goes to the other subcommittee, because that's the subcommittee that's going to be charged with developing that system. And in that subcommittee, we have been talking about this idea of how we're going to manage records, hopefully trying to develop an electronic management system. And so I wouldn't go about programming it, because it might be that they choose a different system and then they have to reprogram it themselves. So I don't think you all need to take the step to program it, but I think having the information readily available so that when it gets to the point that it would be programmed, that information is able to be programmed. And so for me, I think the other thing is I wouldn't want you to program it and then we're going to make edits to it. I think that's what's going to happen. But having the decision points, or what to do with the information once it's given, I think would be really helpful. And here I know that I'm speaking primarily on my own, but as the person who's pretty much working on all of this right now, I would love to have that. And I'm sure that Dr. Hannum, who's also working on what the screening and what the assessment tools are going to look like, would also love to have it. And so if it's possible to focus in on this idea of if yes, then what, and if no, then what, that would be probably the most helpful part of it. And like I said, especially as it relates to areas other than the mental health areas. You can certainly do the mental health areas, but Dr. Hannum and I are both licensed psychologists and can probably cover that section pretty efficiently. And so if you wanted a way to streamline some of your work, leave the mental health stuff to us and focus on the medical stuff, which we know almost nothing about. So, Mickey.
Yeah, so just to speak to some of what Erica had mentioned, and coming back, I think I'm piggybacking on a comment Dr. Treeman's already made. So in the creation of this, we did initially start to include if yes, then ... Took it out for the initial version that we wanted to present to you guys, just to streamline and have things be more succinct. We did notice also specifically that the majority of questions that were prompting if yes, then ... had to do with mental health diagnoses and pharmacokinetics. And so it felt like we needed to open that up to a broader conversation before we could say what that yes would then entail. But that was the majority of what we were finding that too. And it was to be prompted to Sphere 2, Sphere 3 screening, creation of a plan, stabilization via some other intervention prior to engagement, switching meds, all that kind of stuff. And then regarding the electronic version, I have started playing around with that, and that speaks to something Dr. Goodwin had brought up a little bit ago about kind of the exclusionary criteria and everything like that, and that it would have the built-in logic and the decision tree right from the beginning. So if there's something that's going to disqualify or prompt them for the need for further screening, that would be acknowledged in that electronic version right from the start.
Yeah.
So we've been playing with some of that.
And I appreciate all that. Like I said, I think the place where we're going to need the most help is largely around the pharmacokinetic, and then any contraindications based on pre-existing medical conditions. And then again, I'm not trying to discourage you all from programming electronically. It's just that we have no idea what the medical or the electronic system is going to look like. So if you program it in, Qualtrics or RedCap or something like that, and then they decide to use a completely different system, then it's done. And part of this is there's been this really tricky process, which I think everyone can appreciate, and I'm not complaining about, but just calling attention to, in that we're developing this system in multiple subcommittees in real time. And so while I'd love to be able to go in and say to you, we would definitely approve this document, even if we approve the document, in this case, this subcommittee, it would have to go to all the other subcommittees, it would go to the full board, and then once approved by the full board would simply be a recommendation made to the regulators, which would then they could do whatever they want with. And so I'm trying to make sure that you all don't invest too much time and too much energy into things that may not end up being useful. And so hopefully you all don't feel like I'm undercutting you in any way. Again, I appreciate the document completely, and I think the biggest help would be those sort of decision points around medical conditions and pharmacokinetics for sure. Dr. Goodwin.
Yeah, so as this conversation is going on, I get finally locked in on me that we're talking about a screening document as opposed to an intake paperwork. I'm a little dense, so sorry. But it seems to me that as I was reading the white papers, there were some categories. Yes, but you need a safety plan. Yes, but, and then there was like a hard no. It almost seems like the screening document should just be the hard no's, and then everything else should go towards the intake. So we get to the no, like, no, I can't see you. There's no need for an intake or whatever, but there's nothing stopping me from seeing you. Okay, now let's start building a plan. Okay, you're on some of these meds. We may want to do this, and so I can't help but to wonder if a big portion of this wouldn't be better suited for the intake itself once you decided to take on the participant, and then just leave the screening documents shorter, smaller, and it just weeds out the ones you absolutely can't see, saves everybody time, and then you can do all that extra effort when you decide you can't take on a plan.
So, yes, Dr. Gordon, I think it's a very valid point, and I'll certainly hear from the presenters after I answer. But what I would say is the likelihood that this document is going to go through all of the processes and come out the other side looking anything like it looks now is none. It's zero, right? And so what I would say is, that the information is what we need the most, but we'll work on figuring out how it all fits together, and then we'll make those recommendations to DOR. I think there are many things, or to DORA, to whoever ends up being the regulator that regulates the paperwork. But I think even in the way that you're presenting, Dr. Gwynn, think about this idea that if an individual presents with a significant history of mental illness, it doesn't mean a yes or a no. It means an elevation to a different sphere by the way they've written the document, and I think that's an important piece of information. So I actually think that the screener here is fairly comprehensive and would what I would want for an initial screener, with some paring back here and there, but I wouldn't necessarily change it overall. And so I would be really, again, I know I get repetitive at times, but again, it's to save you all from doing work that's likely not going to result in anything, which is worry less about formatting and application, worry much more about content, so that we're getting all the information we need so we can fit it into the system as we develop it, and that'll has already saved us hours and hours and hours of time. So I want to be extremely grateful for this document and just focus us on the direction we want to go in. Wendy.
Sorry, I hit the wrong button there. You guys are brilliant. I sit here in amazement a lot of times because you guys talk so over my head. But anyway, I wanted to make sure that when we're talking about this is available to everyone, so we don't outprice ourselves with some of these facilitators, that it has to be that they can do a paper form, they can do electronic, all of that, as well as make it friendly for our native healers. I want to make sure that we don't go into the Western medicines so much that we forget about those that, we're doing this basically and learning from. So just wanted to put that in there.
All are well-made points. I think one of the ways these data systems exist now is currently as a website where people can access it both online and offline using any type of device. I think if we do allow for the use of paper forms, then we'll have to create some language around how they should be managed, how they should be handled, how they should be disposed of. And I will remind everybody, I think the points made around Native American ceremonial spiritual use of the medicines are really important, and these screening tools are primarily for the facilitated or regulated market, so I don't imagine they would apply to ceremonial use of substances, although the screening document may have really good reasons to be applied to the ceremonial spiritual use, but that would again need to go to that subcommittee for their review. But I think, Wendy, they're well-made points, and I appreciate you making them. Dr. Spear?
Is there a timeline or a soft deadline for the screening tool to be in final draft form for you all?
Not necessarily, but I do think that this is a tool that's going to go along with data collection, data management, and the way that we're entering data. And so I think we want it to be part of the current or the initial rulemaking phase, which is coming up rather quickly. So I would say that sooner rather than later. And, if you could get it to us by yesterday, that would be great. But yeah, this one probably has a little more pressure on it than some of the other things we've been talking about today, just because I think it needs to be ready to go when we start issuing licenses and we start issuing or allowing for the facilitation of natural medicine in the regulated market. So sooner rather than later is what I have for you. Erica.
Thank you. I just wanted to speak to Commissioner Buxton Andrade. Those are really excellent points. I've worked on a med-surg floor with Indian Health Services, and I can tell you that this form is not meant to be handed to somebody at the beginning of their session and say, we'll see you in 15 minutes, let us know when you filled it out. Ideally, a facilitator will sit and go through these questions, each one of these questions, especially for folks of Indigenous folks and stuff. They're not going to understand this language, no matter what kind of language we put it in. They just don't talk like that. So they speak of the heart in very different ways than we do. And so those have to be people that are well-versed in knowing how to translate this to them so that it's in a way that they can understand it. So same thing with making it to an 8th grade level. For those who are illiterate, we're going to have to speak through each question. So those are things that nurses think about, every time we address anything having to do with patient interaction, is making sure that the education is in a form that they can digest and hear it and be educated by it. But those are excellent points.
Agreed. So I think we're going to move on for this agenda item at this point, and we'll expect that the individuals who presented will be back at the January meeting to show us what they've come up with based on the points that they heard in this discussion. Again, really appreciate the hard work on this document. If you could get that to us with a little bit of time in advance to be able to review it in advance of that meeting, and just so we'll come back to this, and I'll say it again later as part of the agenda, but the next meeting for this subcommittee is scheduled for January 10th. And so if there's any chance to get revisions and or an update to this by January 3rd, that would be greatly appreciated, so we had time to review it in advance of that meeting. But if you can't hit that deadline, getting it to us, as either way, I would love to see it back on the agenda for the January meeting. And I would assume that Chair Dunn would as well when he returns to retake his seat as the chair of this subcommittee. So before I move on, let's make sure any other last points around the presentation on the screening tool and or the white paper before we move on. Dr. Goodwin.
I just want to say thank you one last time. We don't know these things, and we don't have the expertise, and we don't know what conflicts and what the hard thing is. And so we're really grateful for your experience and all the work you're putting in. I just want to say thanks. It's not lost on us. We're so happy you're here.
I think I speak for all of us when I say we're grateful for the opportunity to collaborate, that you guys are doing, heroic work. We're available, and we will absolutely consider essentially a hard deadline to follow up in advance of the January 10th meeting. And thank you all so much.
Appreciate all of it. Yep. All right. So now we're going to move to agenda item 5, which is a review and discussion of the consolidated recommendations document for those of so it'll be on your screen now. And as it pertains specifically to this subcommittee, the ethics we're putting on hold for now until we figure out more things. I think we can scroll past ethics because it has not had an update since the last meeting. So what else I wanted to see what are the outstanding questions for this subcommittee prior to going into the rulemaking process. Thank you. So we've been working through a document that Dr. Goodwin had produced for us, whereby Dr. Goodwin had gone through the Oregon regulations and trimmed down a lot of the things that we thought we may need, or kept a lot of things we thought we might need, but trimmed out a lot of the things we thought we wouldn't need. And we'd gone through, I think, a lot of that document. And I'm trying to see if we can figure out where we left off that document. Sorry, I know I'm not being very clear, man. I'm just telling you to do things, but it's not clear what I'm telling you to do. But what I'm trying to figure out is what is left that for this subcommittee that has not been addressed in advance of submitting recommendations ahead of the rulemaking process. So it should be at the bottom of this table. Is that right, Sam?
Sorry, I'm trying to get to it right now as well.
There we go. Yeah, so it looks like we have that in front of us now. The things that this committee has not addressed that were questions that we needed to address. So here we'll see the first one saying a licensed facilitator or authorized personnel at a licensed healing center or licensed premises must transfer psilocybin products to participants within the designated administration area during the administration session. I think there is a lot of work to be done around custody of natural medicine. Some of this is, for me, is still a little elusive if we're not thinking, there's Sam, I haven't seen you yet today, Sam, it's good to see you. But the idea is to say that, we have one mind. We have in one mind a vision of what a healing center might look like, and I think Dr. Goodwin described that earlier, which is maybe a big commercial space where you have spaces that are divided up for where you might have cultivation, where you might have production, and then where you might have facilitation. And I think that side of the thing is possible, but I think we also can see other variations of that, which would be someone who just applies for a cultivator license because they're primarily just interested in growing natural medicine to be used in the regulated market. And then you might have places where they just do facilitation with no interest in cultivation or production. Sam.
I just wanted to mention number 54 here. I think when we were originally when we put this together, I think we were going off of OHA stuff and taking a look at it, and if it really applied in Colorado. And I think looking back at 54 as we're saying licensed facilitators are not prohibited from transferring, preparing, or otherwise handling psilocybin products. I think that's a good place to start. I felt like we did go over some of this section at the last meeting, so I apologize if any of this is duplicative.
No, I don't. In all honesty, unless it's in the minutes, I don't know that I even remember what we talked about at the last subcommittee meeting, and that's only because there are so many of these meetings, and so I think it's a good place for us to start. And so it's highlighted, and so the language here is that licensed facilitators are not prohibited from. So I guess I'm confused as to why would there be language that says someone is not permitted to. So someone is not. That's it. So someone is not allowed to do something. In other words, what we're saying here is that facilitators are allowed to transfer, to prepare, or to otherwise handle psilocybin products. Is that what this is supposed to be saying? I just want to make sure I'm understanding it correctly. Dr. Goodwin put his hand up. I'll let you all. I'll turn the floor over to you, Dr. Goodwin.
Oh, just a reminder. Oregon, they made it hard that these are not considered medical practices for them, like a wellness practice. So some of this language is not going to work for us because we are taking a different route. So just a reminder, we have to chop some of this up for that reason.
Yeah, and here I'm also thinking about things like that happen in the other regulated markets. And so, for instance, in the regulated cannabis market and other regulated markets. But what I want us to remember is that the cannabis market is a retail market, whereas the psilocybin market is a regulated market, where there are other documents that have now been developed that are essentially going to recommend that facilitators maintain a chain of custody with the natural medicines. And so obviously they'll be handling them, obviously they'll be transporting them, and obviously they'll be, especially if they're going to leave the healing center, we want the facilitator to be bringing the natural medicine to the participant, not the participant going to find, they're not going to be able to go into a store and buy psilocybin, I don't think there's any way that a facilitator could be prohibited from transferring or otherwise handling psilocybin products. The one place where I know we've had some debate, both in this subcommittee and on the product subcommittee, is what is the definition of the term preparing, right? So this idea is if I'm going to take raw mushrooms, am I going to turn them into a chocolate, into a tea, into some other kind of food product? And so I think we want to make sure we distinguish the difference between preparing versus producing. And so that's been a conversation on the product subcommittee for some time, this idea that what's the difference between cultivation versus production, and then is there a distinction between production versus preparation? So for instance, if I'm going to take mushroom powder and or whole fruiting bodies and turn them into a tea, is that production or is that preparation? And so maybe that's a good place to see if anyone wants to offer opinion on what is the definition of preparing psilocybin products. Allison.
Thank you, Chair. I don't have a definition to offer you all, but I did want to jump in. This is a question that we actually were talking about at a listening session earlier this week, and just recognizing that there may be requirements that we can pull from in the food safety and food handling world that may be necessary if there's going to be an opportunity for sort of this further preparation after a final product has been tested. And so a lot of these conversations and information gathering are still ongoing from the Department of Revenue's perspective, and we're getting into those details in our listening sessions.
Yeah, and I will say that the product subcommittee is going to recommend that production follow, food safety handling regulations as established in the state of Colorado already. So if you're going to make a food product using psilocybin, we're going to recommend that they follow, best practices for food handling. But I think that this idea of what's the difference between production versus preparation. So then if I'm going to take, let's say that they've produced a chocolate the healing center and the facilitator wants to administer it is unwrapping a chocolate and then the definition of preparation. And so I think this idea of what does it mean to prepare, I think again this idea of what does it mean if they're going to prepare it is making tea production or preparation. And I don't have an answer. I was hopeful that Allison was going to enlighten us with all the information, but we weren't so lucky. And again, I mean, some of this discussion might be the discussion that needs to be held at the other subcommittee because of the non-voting participants who are there and because of the work that we've done. But in terms of from a safety perspective, which would really be what this committee would be concerned with, I think food safety rules for production of products that are going to be like or resemble food or be used like food, I think that makes sense. I did note, and maybe I'll go back to the team that presented the screening tool. In that tool, you had a statement in there that the facilitator would not be able to help administer the medicine. And I wondered why you put that in there, where that came from, and what your concerns were when you put it in there, because I think it might also be directly applicable to number 54 here as we discuss it. So I don't know if those presenters want to come back and tell us why they put that question in there. Of course, they may not be here anymore, but I don't know.
Sorry, I'm still here.
Good.
My understanding, and Allison can speak to this, with the actual medicine product, the facilitator won't be allowed to actually touch the product. So, and Allison, can you speak to that at all? That's my understanding of it. The mushroom would have to be delivered, or the mushroom product would have to be delivered in specialized packaging. We can hand the packaging to the participant, but we can't open it for them. We can't touch the medicine. And then that means that the participant would have to administer it themselves. Am I correct in that understanding, Allison?
I'm going to go ahead and jump in, Chair, if that's okay. That was one concept that was raised during the listening session, and we haven't decided if that's something we are looking to pursue further, and it would have to go through the rulemaking process. We have to recognize that there are challenges if that kind of restriction is put in place, particularly when you think about different modes of administration and how people want to consume their natural medicine. So that was one idea that was offered on the table as part of the conversation, but we're listening to all ideas at this point, so I wouldn't say that's the direction we're necessarily headed.
And speaking,
okay, thank you. I'm sorry, I just didn't realize it wasn't already in place, so I appreciate that. We can certainly take that out, because I would love to see that.
I would say to you, as from a personal perspective, as someone who's going to be helping to write the recommendations that are going to the regulatory agency, that I do not foresee me ever recommending that course of action. One, I think it creates an incalculable number of complications that cannot be addressed, and so if you put someone in a situation where they can't, and I have experience here in some of the ways that we've done observational cannabis research and this idea about handling versus not handling. You know, the idea that if a licensed facilitator can't handle the natural medicines, then you're creating many more obstacles than you are solving problems. And so for me, I don't see what the value is in making that recommendation versus what the harm is in making that as a part of the rulemaking process. And I can be more specific, but I mean, even to the point that when they develop in that screening tool, so what would happen if somebody could not take the natural medicine themselves? Are they then automatically out of the market? Can they not participate? And there are going to be individuals who will benefit from these medicines who will not be able to administer them to themselves, and we automatically want to rule them out from participation. Or then we have to create some sort of workaround where the individual has to have a confederate who's present, where the confederate can handle the medicine, the confederate can administer the medicine. All that seems way more convoluted than it needs to be if we're setting up a regulated market, especially if we're requiring facilitators to maintain a chain of custody, right? Like it creates, in my mind, automatically creates many more complications than it solves problems. Again, that's just my personal opinion. I'm not the only person making recommendations, but I would find it hard for me to sign off on that particular type of plan. Dr. Goodwin.
Not to mention, mushrooms are gross. I mean, I don't know if you've ever tried them, but peanut butter sandwich goes a long way to kind of get it there, right? And the tea is nasty too. So we haven't talked a lot about how it is going to be administrated, but I mean, it is pertinent to bring it up here because, if someone just can't choke it down, well, they may need some help. And
Right. No, I agree with that. But if you think about what we expect the packaging to be, right? Especially if it's going to leave a healing center, I would expect that it would need to be in child safety, child-proof packaging, which invariably is very difficult to open, right? And so if we're dealing with individuals who have existing medical conditions, what might make it difficult for them to open the packaging, then we're already, again, putting in barriers that I don't think would be solvable. The taste or texture or touch, feeling notwithstanding, I think that there'd be issues there. Erica.
And one of the things we've spoken about in the DOR session, and again, Allison can speak to this, but we spoke about just not necessarily needing child-proof packaging. This stuff is never meant to get to the general public. It's not going to get into a child's hand. They won't have exposure to it at all. So that's just maybe cutting down on the cost of the packaging.
But I agree with that 100%. But I think if you put a rule in place where facilitators are not prohibited to handle the product unpackaged, then that would bring back in the need for conversation around the type of packaging, because you're essentially creating a situation that you're breaking the chain of custody, right? Like this idea is if I want the facilitator to be the person maintaining the natural medicine, then they're going to have to handle it. Like in your job, imagine if I told you that you couldn't handle a needle, that the person would have to jab the needle in their own arm, or I don't know what you do on a daily basis. I shouldn't make that assumption, but there are things and so I would just want to understand, I guess before we made that recommendation, I want to understand why. What would be the benefit of prohibiting facilitators from handling the product itself and or assisting with the administration of the medicine? And I don't know if anyone wants to speak to that or can speak to that, but why would it be prohibited?
I can speak to that as well. It had something to do with Allison. You can, yes, I'm going to let Allison speak this because it did make sense at the time, but it had some sort of legal aspect with the facilitator administering the medication versus the facilitator isn't involved with the medication, they're just facilitating. And, we offer a place for that medication to be delivered from a grow center.
Yeah, and I can help provide. There were a lot of different perspectives on the question. So as Erica mentioned, some folks mentioned a concern about just, handling a Schedule I substance and the concerns they had about their licensing, which again, recognizing that other subcommittees within this board are talking about impacts on their licensing, and we didn't really touch on that further, just it was a consideration that someone raised in the listening session. The other side of this was thinking about just handling product that could introduce additional contaminants prior to it being administered, and so there being a concern there that the facilitator is potentially, or if they were kind of preparing in certain ways, could be introducing contaminants to the product, whereas if it was, if the participant wanted to prepare it in a different way, if they wanted to drink tea rather than take a capsule, or if they wanted to grind it up themselves, then is there sort of protection for the facilitator if they're removed from that process? That if it's the participant's choice that they want to consume it in a certain way, the facilitator can say, okay, here's how you prepare it, and then the participant prepares it themselves. Again, all just perspectives that are being shared for our further information gathering and to inform our rulemaking next year.
Sure, yeah, and I'll just say here that I think that all of those things make sense, and for me, still don't necessitate a rule that would prohibit a facilitator from handling the medicine. So I think I would be making the same argument if we were talking about a rule that would mandate that a facilitator had to handle the medicine, right? I think I don't want to overregulate and create these awkward. Again, I've been in situations like this when we've been trying to do observational cannabis research where we're not permitted to handle cannabis, and yet, people all around us are handling cannabis, and it just makes for these really weird interactions that don't. And so I think the idea here would be to stipulate that, I don't know, I have to think about it more, but I don't want to create these convoluted systems that are going to make it difficult for people to manage how the medicine is getting from point A to point B, and then from point B to ingestion. Sam?
Yeah, I think I agree with your points, Dr. Connor. I think this is something that should be discussed in the preparation session, right? How it's administered, how you want the product, right? Do you need something to consume with it, right?
Yeah, I think so. I mean, I think the other part of this is to think about this. So let's say that we've determined that a facilitator has determined that the dose that a person's going to ingest is, 2 grams of whole fruited bodies, and the person only eats 1 gram of whole fruited bodies, but they've unpackaged it, and now there's the other mushroom is just sitting there. Is it going to be the responsibility of the participant to then put it back in the package before they hand it back to the facilitator, so the facilitator can then take it back to the healing center and or destroy it? Because that seems like an onerous process to me, Erica.
Well, one of the concerns as a registered nurse, so an MD or DO or a psychologist, psychiatrist, can prescribe medications, right? I can only deliver medications that have been prescribed. Since this is a Schedule 1 drug and it's starting to come back to me, I think that's one of the things that we discussed is what is this going to mean for DORA, for my license? If I'm handing somebody a Schedule 1 substance, how does that affect my RN license? So I don't know if it was necessarily for the general public, but those were just some of the considerations.
No, what I would say to you is the route that I would rather see is that this body recommend that DOR and DORA put rules in place to stipulate that there cannot be penalty to a license for handling natural medicine as long as the individual is a licensed facilitator. And that's the language we've been talking about in quals and training, is this idea of providing some sort of protection rather than exposing risk. And here, my lawyer has raised their hand, and so I will defer to Ms. Muller.
Thanks. So not getting into too much into the weeds, I just want to perhaps put a little bit on that concept, and to the extent that each one of those licensees has a regulatory board that is something other than DORA. Mm-hmm. So to fully effectuate that concept, you would have to go and make a request to every board to adopt a rule that says we won't do it. We won't take action. So it's not DORA, it's the medical board, the nursing board.
State board of psychologists.
Right. So I'll just throw that out there.
But I do think it would be. I think it's much more likely that this board would recommend that the regulatory agencies seek that permission from the other licensing boards, so that we don't expose individuals to risk simply because they're doing something that they're licensed to do in another area, right? We've known that that's going to be a conflict that we're going to need to address for quite some time, for sure.
With you on that.
Yeah. And I appreciate that conversation, and I think Erica, to go back to one of the points you made, is this idea that we haven't really even talked about who's going to have prescription privileges for natural medicine, right? But I think the likelihood is that it's going to be the licensed facilitator, unless I'm wrong. I don't know. And I put the word prescribe in quotes, obviously, because we don't have prescription. There's no regulations for the prescription of natural medicine, right? So it would be recommendations or the recommended dose rather than a prescription. And my guess is that falls to the facilitator, in the same way that if an individual was going to recommend the medicinal use of cannabis, they can't prescribe it, but they can certainly recommend it, right? And so I think that's one distinct difference that versus where RNs are not able to prescribe medications but can administer them. Here, the facilitator should be able to make recommendations around dose, and then is going to be charged with administering that dose in some fashion. And so if I think about it that way, I think it's hard to imagine a situation in which a facilitator should be prohibited from handling the medicine. Again, I think so Erica, again, in your job, imagine that you were a doctor prescribed a medicine to a patient, and your job was simply to carry the bottle inside and put the bottle on a table. I think you could probably immediately see the number of complications that might come from that. Yeah.
I agree. It's not something that that I agree with at all. Yeah. I would prefer to be able to handle the medicine and create whatever the client needs or the participant needs to ingest it. Mm-hmm. But because that was brought up, I had it in my mind that it was somehow a rule, and so that's why we put that in there. I am happy to take that out.
Well, I have I'll ask another question. So, are you able to prepare medications that need some sort of preparation as part of your license?
Yes.
Okay. So it would seem to me that for this one, we would need a definition that distinguishes preparation from production, because I think those are going to be two very different things. And I think that that's been needed for some time, both on this subcommittee and potentially on the product and Data and Research Subcommittee, where we've talked about developing a glossary of terms or definitions. So it seems like one of the first things to do here would be to talk about developing those definitions. Dr. Spear.
Thanks, Dr. Connor. I think it could also be helpful to look at some of the rules and regs surrounding pharmacy compounding versus manufacturing. So production kind of coincides with the language and the definitions of manufacturing versus compounding is more so preparing. So I think, not only looking at the food side potentially, but also the pharmaceutical side could be useful.
Right, so can you give us, I don't know if you can, and if you can't, it's okay, but can you give us an idea of what compounding would be? Like, what do you compound?
So compounding is basically another way to prepare a medication into a different dosage form. So for example, in the end of life, a lot of compounds are made because folks cannot take a pill, for example, or a medication isn't available in liquid form. So these medications are compounded into a suitable dosage form for the patient to be able to tolerate or receive the medication.
And I don't know if you can speak to the current ketamine market, but my understanding for the current ketamine market is someone's going to use ketamine at a low dose in a facilitated setting, they have to go to a compounding pharmacy to get lozenges, right? So turning the ketamine liquid into a lozenge is another thing a compounding pharmacist would do.
Exactly. So ketamine is available as IV intravenous form only, and is very commonly compounded into troches, lozenges, and in some cases, oral solutions for oral or sublingual administration at the end of life as well.
And you would consider all of those processes to be akin to preparation, not production?
Correct.
Or manufacture in your language. Sorry, I'm trying to translate, but yeah.
The line is thin, and I don't know where those definitions fall. Some people or some entities will compound, and they've been accused of manufacturing, for example. So I think that I can't answer your question there, but I know that the line is gray and it's thin, and it's probably worth looking at some of those rules and regs.
Yeah, I think that's a good point. I think we've talked at a number of the subcommittee meetings, again, both with this subcommittee and the product research and data subcommittee, about preparing, about definitions and about where we're going to draw those lines and potentially having them not be so thin and or porous as a way of creating some clear guidelines. Because we expect that they'll be licensed for cultivation, they'll be licensed for production, and they'll be licensed for facilitation. And so I think we'll want clear lines in between those different levels or spaces. So if we stick with 54, I think the next step would be to continue to work on definitions, unless I've misread this in some way. Sam, thoughts on defining preparation versus production?
I think that's probably a good call. Yeah, I don't know. I defer to you here.
I just want to make sure that we're moving in the direction that makes the most sense, and to me, and that that I'm gonna leave Chair Dunn in a good spot when he comes back. And I think this is something that I was going to be working on for Product Safe Subcommittee anyway. And so once again, I'll take the first leap into this pool and start working on definitions for these things, as I think that they serve both two of the three subcommittees that I sit on. The next one as well, 55, says the licensed facilitators are not for any psilocybin product while they are facilitating a preparation, administration, or integration session, regardless of whether the facilitator is also a licensee representative of a service center. So I'm assuming this language is the Oregon language, because we don't use service center or licensee representative, right? So here again, I would say that this one either needs to be rewritten, and it probably can be deleted, because we have stipulated that the licensed facilitator will be the custodian of the natural medicine, and thus they would be transferring, potentially selling, which we haven't even really gotten into yet unless I've missed it, or otherwise handling the product, yeah?
Yeah, that sounds good to me. No need to overcomplicate it.
So you're suggesting we delete it, Dr. Goodwin? Is that what you're agreeing with? All right. I would agree that we should delete number 55, because, again, we've already developed language around the idea of the facilitator being the custodian. 56 says participants may mix psilocybin products with packaged food or packaged beverages prior to consuming, as long as the packaged food or packaged beverage was unopened prior to mixing. Potable water is not required to be packaged. So here I think we're clearly into the space of preparation and how the participants may want to prepare. And this seems to be that if the participant wants to mix it in some way, they'd have to bring it and what they want to mix it with in an unopened package to the administration session. I don't know how I feel about that, so I'm going to think about it while I defer to Dr. Goodwin.
Yeah, I think this is a way to get away from the commercial kitchen thing, right? So if I'm going to make my own brownies at the house, there all these questions start to come into play. You know, is it a sanitary facility? You know, the ingredients that are being used, blah blah blah. And so that's why if you are going to do these products, you have to go to a commercial kitchen and prepare that. I think this just gets them away from that, saying that it was a prepackaged thing. I just opened it up and we mixed it up and we used it. I didn't do any like straight cooking, and I think that's kind of what's happening here. That was my read on it.
Yeah, I don't think I have a problem with this rule as I think about it, in that it could, this idea to say that if the person wanted to bring it, to prepare it in a certain way that a facilitator wasn't permitted to do, that it would allow for that, right? Say, like I say, if I brought some prepackaged food, I'm trying to see if I'm missing any of risks that it presents versus problems that it solves, and I don't know if it. Can anyone think of any risks that are presented with a participant bringing their own product in, as long as it's prepackaged and sealed up? Allison.
At the risk of speaking out of turn, because I am not a chemist, but as some of you members are familiar with, when our MED chemist, Davis Grant, he and I were having a conversation, and he was just sharing with me that I don't know what the risk is, and I'm not sure that there are studies out there that say what the risk is, but recognizing that food chemicals also interact with the compounds in psilocybin and psilocin, and so just thinking about that, I don't think there's enough there to necessarily say prohibitive, but there is a risk by saying you could bring any type of prepackaged food and mixing it with your natural medicine for consumption. So just wanted to point that.
So if they were going to do that, at least until we had better data, we may want them to sign some sort of release, which means they couldn't hold the facilitator liable if there was some interaction that we don't know anything about. Dr. Goodwin.
I just want to make sure I understand your question. So they're kind of gross. You want to make a peanut butter sandwich, but someone's like, I prefer Jif over whatever. Let me just bring my own peanut butter. That's what you're saying, that we're okay as long as it was sealed and you brought whatever kind that you wanted. That's what you're saying, right?
I am presenting that as an option and wondering if there are inherent risks that I don't see to that. Yes.
I did. I talked to one person that said that, and I don't know if this matters, but that you have to ingest it, right? Like if you take mushrooms any other way, it's lethal. Like you try to smoke it or you try to, inject it. Like there's something in the enzyme of the stomach kind of negates the toxic part of the mushroom. Did I get that right? Any doctor who knows more about this?
I am not intelligent enough to speak to that issue.
I have heard that though. Like whatever it is, like you have to eat it. Like it has to go through the stomach and so that the enzymes can like break out the toxic part of the mushroom because it's fungus. So
Erica, did you raise your hand to answer that question?
Please, thank you.
I did. Mushrooms are, and most medications, and Dr. Spear can speak to this as well, they are changed, the absorption rate can be changed by the consumption of food at the same time. So, for example, if you ate a giant hamburger and took the mushrooms, that could really slow the rate of absorption. Now that said, as far as bringing your own foods in and concerns about contamination, I can tell you in the hospital, when people were coming out of surgery, colonoscopies, they were usually very hungry, and people would bring in burgers from down the street. We had no issue with that, and sometimes they were getting pain medications. So I don't foresee any issue there other than the slowing of absorption. A small teaspoon of peanut butter, I don't see that being an issue. It will slow it a little bit, but probably a negligible amount. But as I said, I would probably refer to a PharmD on that.
Just so I'll come to you in 1 second. First, I'll go to Dr. Spear and see if they have comment on this issue.
Thanks. I do agree with Erica on that. And typically, the fasting for a journey is ideal, but probably not necessary. But to the packaged beverages, I guess we can't forget about people who might try to bring alcohol. But I think that's captured elsewhere.
Yeah, co-use is prohibited in other areas, and so if they brought alcohol, it wouldn't be permitted. Dr. Spear or anyone else, any comment on the toxicity of psilocybin if smoked and or and administered in any way other than ingested? I haven't seen any literature on that, but Dr. Goodwin was asking about.
That's interesting, and I can't really answer that. I haven't seen literature and haven't heard otherwise.
Thanks, Erica.
I would highly recommend against smoking.
Yeah.
I'm also a mushroom cultivator. Mushroom lung is a thing, and you would be ingesting into your lungs spores and all these other types of things that should not be there. I would really recommend against that. I don't know if there's any research or data to support it, but that's my initial feeling.
And then I promise I'm coming to you in 1 second, Ian, but my memory is that and maybe this is what you were going to speak to, Ian, but my memory is that the legislation stipulates that they must be ingested, or am I misremembering that? Am I just making that up? Is there Ashley, is there anything in the language of the bill that suggests that you have to eat them rather than do anything else? Or swallow them, I should say?
Not that I recall, but I'll take a look.
All right, thanks. Ian.
Thank you, Doctor. Can you hear me okay? I'm sorry.
Yep, we can hear you.
Okay. For what it's worth, I don't believe that there's anything that's specific to methods of ingestion in there. I do have some concerns in regards to packaged foods and what can be prepared and what all can be presented. For example, I know that there are things that are deemed to be enhancers to a mushroom experience. For example, yohimbe bark. And I question whether or not there will be an ability to properly regulate what is being added in relation to prepared foods. At the same time, I would say anecdotally that an outright prohibition on all foods and drinks during a session is also not recommended, recognizing that many people, while in a facilitated session, sometimes have a craving. Oftentimes fruit is offered at fruit, vegetables, whatever. Lots of water is frequently consumed during a session. And so I think that there's a careful road to navigate in terms of prepared food and what's permitted and what is prohibited. And then if I may also quickly, just in regards to the conversation about compounding and preparing versus manufacturing, I also think that there is a very thin line here. If somebody is going to be taking mushrooms and turning it into a lozenge, for example, I would liken that to a final prepared product. And I would go so far as to suggest, other than a participant that is changing the composition of a product, that what is going to be offered to a participant may be best if it was in that final prepared product. You mentioned somebody might want to crush it up and take a tea. Well, the ability for a licensed facilitator to offer a tea option is certainly going to be available, and that could be a product that somebody chose to manufacture. But I think if you are separating between a manufacturer and a preparer, it is an opportunity to create a loophole that would eliminate liability, as well as I just think that it should be very careful about preparation and preparers not being licensed, given the potential for challenges and conflicts and or adverse events. Thank you.
Thanks, Ian. We have developed language around the idea of what the difference between an additive and an enhancer and then a non-active ingredient. And so I think you could make the personal food limitation, like restrictions against personal food or drink, in that they couldn't use anything that included an additive or enhancer, but could use foods that were consisting primarily of non-active or inactive ingredients. Do you think that would solve the problem?
I think it could. You know, the hope is that people will be honest and forthright with their practitioner, with their facilitator, and that they're not going to be preparing something that, you know, trying to sneak something in. But as long as there is an understanding that those packaged goods, as you suggested, don't contain any of the additives that are not going to be permitted, and it's clearly articulated, and there's an opportunity, you know, maybe if it's a packaged good, I don't know how far you want to go as far as examination or ensuring that, you know, a facilitator knows that whatever packaged good is being brought in is something that's permitted. I just note the concern that the ability when somebody's bringing something in, they could in theory add to it whatever they wanted. MDMA comes in liquid form, and so if somebody wanted to sneak that in, just like sneaking into a concert, somebody's probably going to find a way to do so.
Yeah, and I appreciate that, and I think that we certainly can't legislate for every single one of those loopholes, but we can certainly be careful to pay attention to the vast majority of them, or to try to provide as much protection as possible. I appreciate those points, Ian. I did want to ask if there is no language anywhere about method of administration, then should this subcommittee be considering making a recommendation for such language based on available research and data? And so I do think of this idea that the subcommittee charged with safety should be thinking about whether we should be restricting methods of administration or making recommendations around restricting methods of administration. So I'm wondering if I can if we can add that to the list of things that we need to think about, or I don't think we'll get to an answer today necessarily, because I have a hard stop at 4:30, and so I'm going to start winding us down. Unless someone else wants to take over the meeting and go even longer. But I just want to see if we can put that on our agenda to have a more detailed discussion about around whether we should be making a recommendation on methods of administration. Thoughts, concerns, comments, questions about adding that as something we tackle in this subcommittee?
No, I support it.
Thanks, Dr. Goodwin.
No, I think it's a good decision. We'll make sure to note that for the next agenda.
Great. See, and then I think let's just look at 57, and then maybe we'll work towards adjournment after 57. So 57 says a licensed facilitator or authorized personnel of a healing center or licensed premises shall not permit participants to mix psilocybin products with any items other than packaged food and beverages, including but not limited to, and I'm assuming this list continues onto the next page, Amanda, homemade food and beverage items, dietary and nutritional supplements, including herbal supplements and products derived from cannabis, prescription and non-prescription drugs, and any intoxicant. I think if we do decide to adopt the allowance of pre-prepared foods, we should definitely look at these qualifiers and maybe additional qualifiers. But I think until we have an answer on 56, then 57 might not be ready for discussion. And I think that takes us to the end of the table. Were there things below the table, questions to address, right? So
yeah, I think for this section, we're not going to be able to cover this in time. So I think for board members to review the section below prior to the next meeting and provide any edits, comments, or anything, please, at least 1 week before.
Right, so I'll say we're charged, Sam has just charged us all with homework, which is to review the text in blue under the questions to address for the next meeting, and I will also work on at least developing preliminary definitions for the differences between cultivation, production, and preparation, both for this subcommittee and for the data products and research subcommittees. And with that, I will move on from this agenda item, which takes us to the next part of the agenda, which is to determine if Ashley thinks that we need executive session. No indication of need for executive session. So then we'll move towards adjournment, and so we'll cover the items we need to cover. First is to stipulate that the next meeting is scheduled for January 10th, 2024 at 1 p.m. Sorry, the next meeting, I got confused because my script has the date, has today's date as the next meeting date, which obviously isn't going to work. So anyway, I would like to thank everyone for your attendance and participation during today's meeting. Before we adjourn, there are a few items that need to be addressed. As I just noted, the next meeting will be held on January 10th, 2024 at 1 p.m. Please remember that your attendance is necessary to ensure a quorum for the meeting. Next, I'll go through attestations. Do you attest and affirm that all conflicts of interest have been disclosed and that confidentiality of all board matters has been maintained since the previous board meeting? Chair Dunn is absent. Dr. Bradley Connor, that's me. I read my own name. I do attest. Dr. Goodwin.
I attest.
Is Commissioner Wendy Buxton-Andrade?
I attest.
I don't believe, staff, that there are any other subcommittee members still at the meeting.
I'm still here. This is Stacy, and I attest.
Apologize, Stacey. Thank you.
No worries.
I'm still here too. This is Tina, and I attest.
Wow, I was really wrong. Thanks to both of you for correcting my mistake, and I apologize for not recognizing that you were still both here.
Sheriff is on here too.
Say it again, Sam.
Sheriff Lucero is here.
Oh, I didn't even. Sheriff Lucero, do you attest?
I attest, yeah, sorry I was tardy, I didn't get on until about 1:12, but have a Merry Christmas, everyone.
We're happy to have you here, yeah. With that, I'll call for a motion to adjourn the meeting.
So moved, Dr. Goodwin.
Thank you, and a second.
Wendy Buxton Andrade, second.
Thank you. All those in favor of adjourning the meeting, please say aye. Aye.
Aye.
Any opposed? Any abstentions? The motion